Good morning, everybody. We're going to get started in a couple of minutes. For those of you who are live here in Cleveland, we're so glad to see your faces, or what portion of your faces we can see with the masks. Unfortunately, today I am the hall monitor, so I am tasked with being like a flight attendant and telling you that this isn't coming from me personally. This is coming from Thompson Hine. When you're up on the public floor, you are required to wear a mask at all times unless you are actively eating or drinking. So yes, I will come by and give you a hug in the middle of the presentation if I really have to say, like, can you put your mask on? And I don't want to do that. So if you can abide by the rules, especially as you're in here, going to the bathroom, picking up food outside, I'd really appreciate it. It is for the protection of other people here at the seminar and also for our staff who are staffing this event. So I really do appreciate that. I'm Nancy Barnes. For those of you who haven't met me before, I'm a partner in the labor and employment practice. I'm based here in Cleveland, and I am the head of the labor and employment practice group. Today we are doing this webinar as a hybrid presentation. This is our maiden voyage trying this, obviously COVID induced. As you know, last year we did not even have a webinar or a seminar. We do this annually, and so this year we were happy to be able to have an in-person portion. But we did want to also do it by webinar to open it up to people who were not comfortable coming down in person, who were in other locations. We have some people who are under the weather who are appreciative that they can participate in the webinar. So for those of you who are on the webinar and you are looking for CLE credit, we will be sharing CLE codes throughout the presentation, which will end up needing to be recorded on your affirmation form. This form can be found in the handout section of the GoToWebinar panel on the right-hand side of your screen. Please click and download that form now, and I will be repeating CLE codes at the end of the morning presentation. If you're confused by any of this, feel free to email me afterwards, email my assistant, Laura Montgomery, and we'll help you with the CLE credits. For those of you who are here in person, just make sure you've signed in at the desk. And if you sign out early or need to take a break to do phone calls, etc., just make sure that your time is being recorded accurately. For the next few hours, we will be providing an update on employment law issues from the past year, including hot topics in employee benefits, review of new issues related to non-competes and trade secrets, and issues related to diversity, equity, and inclusion. When I first started planning this webinar and seminar, I really was going to avoid COVID. I was like, everyone is sick of hearing about COVID. They're sick of hearing from me about COVID. And so I was going to cover all issues unrelated to COVID. And then President Biden did not consult with me before issuing the OSHA ETS, which of course my phone has been ringing off the hook. So we are going to cover a little bit related to COVID, OSHA, religious accommodations, and everybody's favorite subjects in that regard. So I apologize in advance. Due to the large audience in the webinar portion, we are not going to be addressing questions during the webinar that are in the chat. But if you do have questions, feel free to put them in there. I will try to respond to them once I'm not speaking. So feel free to do that. For those of you who are here in the room, feel free to raise your hand, interrupt me at any time. I'm happy to try to address questions in the time that we have here today. And obviously, if you have questions, particularly those of you who are attending virtually, feel free to reach out to your regular Thompson Hine attorney regarding any questions that you have about our presentation today. We will be sending the recording and the slides to all registrants within 2 business days. So now we will go ahead and start our program. Okay, so what I'm going to be talking about today is this is an annual presentation for those of you who are with me every year, employment year in review. And so we're going to be touching on specific highlights from court cases, legislative developments, and of course COVID, because that's been a big part of our 2021 employment law year in review. Okay, so a quick agenda in terms of things that we're going to be covering today. We're going to talk a little bit about the fallout from the Bostock decision from the U.S. Supreme Court, which actually came out in 2020. We didn't talk about it because we weren't here last year, but we will be talking about that and some of the follow-on cases that have occurred since that decision. We'll be talking about some recent Sixth Circuit developments. For those of you here in Ohio, here in Cleveland, you know the Sixth Circuit is our circuit. For those of you on the phone, it's the circuit that covers Michigan, Ohio, and Kentucky, and Tennessee. And we'll be talking about some other appellate court decisions that would be of interest to everybody. In addition, we'll talk about Ohio statutory and legislative developments, hot topics, some EEOC statistics for fiscal year 2020, which came out a few months ago. And again, sorry, the OSHA emergency temporary standard and COVID-related issues. Okay, so the first thing I want to talk about is the Bostock case, which, to refresh your recollection, in June of 2020, this was one of the last decisions that came out from the Supreme Court in the 2020 term, was dealing with whether or not Title VII provides protection against discrimination for people who are gay. This was Judge Gorsuch's word, or transgender. What this means is relating to someone's sexual orientation or their gender identity. Are those sorts of issues covered by Title VII? And the court, which was made up of a different set of justices than it is today, ruled in a 6-3 decision that yes, discrimination based on sexual orientation or gender identity is discrimination because of sex, which is obviously prohibited under Title VII. And many state laws that follow Title VII as sort of their guiding principles in terms of determining what their own state laws mean. According to Judge Gorsuch's majority opinion, he said this is because employers were discriminating against employees because of a certain, basically, stereotype about who that individual may be attracted to, whether it's a man, a woman, and those things were inherently because of someone's sex. So here are some cases that have dealt with some issues that arose after that decision. The first one is Jimenez versus Laborers Welfare Fund. This was a case addressing whether or not that decision applied to the provision of benefits. And in this case, the union was failing to enroll the wife of a female employee in the health plan. And the court in that case said that that would be discriminatory under Title VII. Doe versus Triangle Donuts is a case out of the Eastern District of Pennsylvania. This was a case involving a transgender employee who was born male but presenting as female. And this was a case, as I started looking at some of the transgender discrimination related cases, I will tell you, most of the cases that show up in public opinion or in published opinions are not sort of the, oops, I forgot, I'm supposed to say he or she, or sort of those, oh, they just changed their name yesterday and I called them by their former name. And those are not the cases that are being published. We're talking about cases where there is daily harassment, completely different rules applied to individuals, customer harassment of individuals. I mean, things that are very, very obvious that they are not just sort of an, oh, oops, I forgot type of situation. So Doe versus Triangle Donuts is a great example of that. This individual, unlike other female employees who were allowed to wear nail polish and makeup, this individual was told that she could not wear nail polish, she could not wear makeup, she could not wear certain types of clothing. So it was a very targeted attack. And of course, the court said, oh, listen, with the Bostock decision, those days are over. And so we're going to say that that claim is covered by Title VII. Merriweather versus Hardtop is an interesting case out of the Sixth Circuit. This involved a professor at a public university. And for those of you who've been at my presentations before, we sometimes talk about who has First Amendment rights, when does the First Amendment apply? I have 3 teenage adult sons who have learned in my household there's no such thing as the First Amendment because as their mother, I'm allowed to limit their speech. Same thing with a private employer. Private employers can limit employee speech and say, you cannot say fill in the blank. You cannot talk about politics in the workplace because it's creating all of this dissension, et cetera. You have to talk about that somewhere else. A private employer absolutely can say that. No First Amendment violation there. In this case, this was a professor at Shawnee State University, which is a small public university in Southern Ohio. This professor had a religious objection to the idea of someone having transgender status, or that God would not give the appropriate sex gender at birth. And so he was resistant to the idea of allowing a student to say, this is my preferred pronoun. And so there was a Title IX investigation at the university. And I will tell you, in this case, one of the things that I think is telling in this case and some others that we've seen in recent years is that the court somewhat seemed to be addressing the way the religious objection was handled. So there was a lot of belittling of the professor for raising this issue, basically saying that this could not be a religious objection, laughing at him, not addressing the arguments that he was raising about his religious objection to this policy, not listening to his suggestions for how he could try to comply with the policy, but at the same time, uphold his religious beliefs in this regard. So there was a complete disdain for that. And I'm not saying that that changed the ultimate decision, but I think it may have influenced the outcome. So in this case, the Sixth Circuit did say that the professor who had appealed his discipline for not complying with the university's policy with respect to the use of pronouns with respect to students, they said that he could not be terminated or disciplined because he was exercising his First Amendment rights in that regard. So it's just an interesting case, but it does sort of illustrate that sometimes it's the result that matters and that's what's being litigated, but sometimes it's also the process that's being looked at and can put you in a very unfavorable position in front of a judge or a jury. Okay, quick Sixth Circuit update. So in a case involving the city of Cleveland, for those of you who are here with me, the court was facing a question of whether the plaintiffs could bring a claim based on shift assignments. So these were EMTs who were being assigned to shifts, and the city had decided to assign certain white EMTs to certain shifts because they did not want to have all Black employees on certain shifts. And the city, the Black employees complained about this, saying this was a violation of Title VII. And the city argued that its decision had no adverse economic impact on the plaintiffs. And so therefore, there shouldn't be a claim. So we're going to do our first quiz question. So you all have little clicker things in front of you. So let's talk about who's right here. Do we think A, the plaintiffs are right in bringing this claim because any change in working conditions is sufficient to support a claim? Is it B, as long as they can show that they've suffered some economic consequence, then they'd be right? Is it the plaintiffs because if they show other impacts like reduced seniority benefits or fewer supervisory responsibilities, that's sufficient? Or is the city right as long as it can show that the actions it took were to promote its diversity objectives? What do you guys think? And I apologize to those who are online. We did not include a virtual quiz option. You will just have to go with those who are in the room to pull away. And hopefully your clickers are working. So far, I only have 7 responses. So either you didn't push the button hard enough, or your clicker's not working, or you're not participating. So give it a try. A few more responses. Okay, let's see what we've got here. Okay, oh, a variety of responses. This always makes me happy. Okay. So first of all, so 3 of you here said plaintiffs, if they can show any change in working conditions. Let's think about that for a second. Would that mean that if you replace the desk in their office, it's mahogany wood before and now it's maple? Well, that's a change in working conditions. I'm now working with a desk made out of a different type of wood. Would you be able to bring a claim on that basis? Let's hope not, but the answer is no. Okay, so that is not the correct answer. B, are the plaintiffs right as long as they can show an economic consequence? Is that the standard that's been laid out by the Supreme Court for saying there's been some sort of adverse action? It has to have an economic effect. Incorrect. It does not have to have an economic effect. So it does not have to change your compensation or your bonus structure. It can be other changes to terms of employment. What if they can show an impact like reduced seniority benefits or fewer supervisory responsibilities? What does that sound like? That sounds like a material change in their terms and conditions of employment, which is what we're looking for. So very, very minor changes. Those are not going to support a claim, but something that impacts something like their ability to have supervisory responsibility, seniority benefits. In this case, being able to choose their schedules was based on seniority. And so changing that based on race is something that is going to be impermissible under Title VII. And the city, yes, promoting diversity objectives, sure, that sounds good, but when the actual action is based solely on race, and that was the only justification for the decision they made was, well, we want to have some more white employees on the day shift, that's not going to be upheld. Now, part of this is, this opinion came out of the Northern District of Ohio. Judge Gwynn, for those of you who are familiar with our bench, issued the decision on summary judgment and held that the practice was based on race and it was discriminatory. But in his opinion, he said because it had no economic impact, there was no remedy, and so he dismissed the case. The Sixth Circuit said, no, we disagree with that. They said, for example, employee shifts are terms of employment. I mean, that is something that materially affects somebody's employment. In these cases, the way shifts were assigned originally was based on seniority, and then the city decided, well, no, we're going to do it based on race. Again, Judge Gwynn said, yeah, that's racial discrimination. That's what he says in his decision, but he says there was no materially adverse employment action. And so the Sixth Circuit made it clear that we're not going to focus just on economic harm. We're going to look at all material changes to terms and conditions of employment. Okay, another case to just bring to your attention, which is interesting, especially for those of you who are HR folks in the room, is Jackson versus Genesee County Road Commission. This is a case, again, out of the Sixth Circuit from this year, talking about the retaliation provisions, an opposition clause and participation clause. So opposition clause is for people, sit anywhere, you can walk in front, don't hide. Make yourself at home, make yourself comfortable. So retaliation can come from people who are raising objections to practices or opposing discrimination in some form, or it can arise from participation, meaning I was called as a witness in the investigation, I'm talking about some conversation I observed or whatever, I'm participating in the process related to an investigation. In this case, what happened was the HR director at this organization had raised issues about the way that the organization was dealing with employees, and a particular employee had various complaints against them. And the problem that they had here was the HR director, she was basically doing her job. So she wasn't sort of independently raising these issues. These are things that came to her in her role as an HR director, and then she was raising them up the chain. And she said she ultimately was being retaliated against for raising those issues. The lower court said, well, that's part of your job. That's not really protected activity because you're basically just doing your job. And the Sixth Circuit agreed and said it does not matter if the protected activity is sort of part of your role as your duties as an HR director or as legal counsel. If you're being retaliated against for engaging in that behavior, that is going to satisfy the protected activity prong for a retaliation claim in the Sixth Circuit. Sixth Circuit in the ADEA but-for standard. So those of you who are really down in the weeds on discrimination claims, you may recall that there is a different standard under the ADEA, which is the Age Discrimination and Employment Act, versus that which is applicable to a Title VII claim based on pick your protected category, gender, race, religion, etc. In the case of Pelcha versus MW Bank Corp, this is again from the Sixth Circuit, they affirmed the dismissal of this case where the employee failed to show that age was the but-for cause of termination. So when a plaintiff comes forward and says, well, there were a bunch of reasons I was terminated. One of them was my age, and then there were a myriad of other issues. If they cannot show that age was the but-for, if it were only related to age, then we've got a claim here. If they can't show that, then they're out of luck. In this case, the employee, was pretty obvious that she had engaged in insubordination. I mean, again, the facts kind of help in terms of figuring out what the decision's going to be here. But she was like pretty insubordinate to her supervisor, and that was what the employer said was the basis for her termination. And there was a lot of uncontested evidence about her insubordinate behavior. And so that really outweighed some other evidence that came in regarding comments from the CEO. We love comments from the CEO. And in this case, the CEO had talked about certain employees having a limited shelf life. Yeah, you're like, oh, that's like, how bad is that? I don't know. CEO also talked about wanting a younger workforce. Okay, well, that becomes a little more problematic because it's hard to say like, well, shelf life, like that could relate to being, you know, fresh or funny. It doesn't necessarily have anything to do with age. But once you start talking about I'd like a younger, more vigorous, energetic workforce, then that becomes a problem. So again, this is an interesting case because some have questioned whether Bostock, which talked a lot about but for and what the standard is under Title VII, whether that would be carried over into the ADEA context. And the Sixth Circuit, at least for those of you who are in this jurisdiction, reaffirmed the gross standard that has been in place for I think close to 30 years now as far as having but for causation. Okay, we're going to switch a little bit to Ohio law. We had a big development this year, which I think kind of went under the radar a little bit. I don't know if it was because of COVID, we're all distracted by that, but the Employment Law Uniformity Act, ELUA, became effective this year in Ohio, April 12th, 2021. For those of you who watched the court dockets, it was hilarious the first 2 weeks of April. So many cases from a certain law firm who will remain unnamed were filed because this was their last chance to get in under the wire without having to comply with this act and to be able to sue individuals under Ohio law. There's still a way to do that with some exceptions. We'll talk about that. But there were a ton of cases filed in the first 2 weeks of April. So now the ELUA now mandates that an employee has to file a charge of discrimination with the OCRC before filing suit. As you may recall in the past, individuals who wanted to, you know, they're fired and they're like, I'm going to sue you as they're walking out the door. I mean, they could go and file a complaint in the courthouse that afternoon, and there was no administrative process that they had to go through to assert claims under Ohio law. That has now changed. They do have to go through a charge process just like you do if you're filing a federal claim. But the charge has to be filed within 2 years. So they have a fairly long period of time to meet that administrative requirement. So it's no longer 180 days. That's what it used to be. It does eliminate supervisor liability unless the supervisor or manager acted outside the scope of employment. So I think this is going to be kind of interesting. So you may recall in Ohio, there was a case called Gennaro, which again, I think was decided 25 years ago, which actually made Ohio law very different from federal law, which federal law, Title VII, you cannot sue individuals. But in Ohio, under 4112, you could sue an individual. And many times, for those of you in the room, you'll be really happy to hear this, it wasn't just the manager, the person who was allegedly harassing the employee, but it was also the HR person who conducted the investigation and somebody else who was a decision maker in the process. And so lots of people were gathered among the defendant group, and most people didn't particularly like being in the defendant group. So now I think that's going to be a lot more limited, but there is still the possibility for bringing claims against individuals. And we're going to talk about what that means from a strategy perspective. But for individuals, it's kind of interesting because it has to be outside the scope of their employment. So if the individual was acting outside the scope of their employment, is the employer still liable for that behavior? Well, most of the time, what most plaintiffs are interested in is who has the bigger checkbook. Normally, the employer has the bigger checkbook. And so now they've got sort of this conflicting position of the supervisor was acting within the scope of employment, well, then you can't sue him or her. If they're acting outside the scope of employment, how is the employer responsible for that? So I think it's going to be kind of interesting. The statute of limitations, most people were really happy about this, has been shorted. That sounds like a stock sorry, typo, shortened from 6 years to 2 years. So now you're going to have a much, many of you have litigation holds and things that are sitting out there lingering, waiting to see if somebody's going to file a claim. Now, at least under Ohio law, that statute of limitations is 2 years. So what are some key takeaways here? You're going to have more involvement from the OCRC. Is this a good thing? Is this a bad thing? We can debate that. The OCRC is pretty backed up, as is the EEOC. I have many charges that have been pending for 9 or 12 months. So it's unclear exactly what's going to happen. But I think the good news for employers in Ohio who are dealing with Ohio employees is you're going to have more of an opportunity to mediate and settle. So sometimes we make decisions about, are we going to offer this person a package on their way out the door? We're trying to weigh, like, what are the risks? Is this person litigious? Because they now have to go through an administrative process, there is going to be almost a forced opportunity to say, okay, now this person has filed a charge. Maybe we want to put something on the table. Maybe we want to do a settlement agreement, give them a little bit of something and make this whole thing go away. So it does provide another step in the process. It's making it harder to sue individuals, which can be a good thing. And this will help you in terms of, sometimes we want to consider removing cases to federal court. Sometimes it's because of the jurisdiction the case was filed in. Sometimes it's the particular judge that was drawn in a case. And before, when you had an individual named as a defendant in the case, typically they were a resident of the state of Ohio, which meant you could not remove that case to federal court under most circumstances. So this really changes that. Age discrimination used to be like a completely different sort of procedural issue under Ohio law, and now it's basically going to fall in line with all of the other ways that we deal with race, sex, religion, other types of discrimination. Very important is that this statute codifies the anti-harassment provisions about how you can get an affirmative defense with respect to harassment in Ohio for Ohio-related claims. So those of you who are as old as I am, go back to Farragher and Ellerth. Those may ring a bell with you. Federal affirmative defense when it comes to hostile work environment and harassment claims. Those cases were decided in 1998. Little aside, I actually worked for the law as a law clerk for the judge who was dealing with the fee petition in those cases, which was actually very interesting because the plaintiff got $1 in damages, and her fee petition, I think at that time, was $600,000. So it was interesting. But anyway, for your purposes, what you need to know is that to take advantage of this affirmative defense, which is something that can be very powerful if you're involved in litigation, this is what you have to do. You have to have robust anti-discrimination policies. Most of you probably have something close to robust, if not robust. You have to have properly trained your employees on workplace behavior and complaint procedures. We're going to come back to that in a second. You have to have exercised reasonable care in preventing and correcting harassment in the workplace. And the employee has to have failed to take advantage of the employer's complaint procedures or other preventative or corrective opportunities. What does this mean in the current environment that we're in? Well, one of the things is, many of you I've talked to about this, many of us have kind of like the training and stuff that we used to do every year, every other year has kind of fallen off the table because we don't have people in the workplace, or we've been distracted by COVID or other things on our plates. Be aware that in order to take advantage of this affirmative defense, you want to be able to show that it wasn't 2018, 2019, the last time you reviewed this policy with your employees. So think about that. You can do training virtually now. All of us have gotten much better at Zoom, GoToWebinar, for those of you who are joining us today virtually. These things are a lot easier to do now, but think about that. If it's something that's kind of fallen off, add that to your 2022 to-do list. Okay, let's talk statute of limitations. We're going to do a little hypo here. Okay, so ABC Company is really pleased that the state of Ohio has finally shortened its statute of limitations, but it still thinks that 2 years is too long. It includes a provision in its signed offer letter that employees do have to sign before starting with the company, that the employee will agree to bring their claim about their employment within 6 months of the occurrence, and if they fall outside that window, then they are waived. Susan was terminated in January of 2021 and just filed suit alleging gender discrimination in Ohio State Court without filing a charge. ABC contacts its counsel because they think that Susan's claims can be dismissed. Are they correct? A, no. Shortening the statute of limitations in a written agreement with an employee is illegal. B, no, because Susan did not need to file a charge because her claim arose before the effective date of the statute. C, yes, because the contract terms in the offer letter are effective and reduce the statute of limitations. Or D, no, because an offer letter is not a formal agreement. So what do you think? A, B, C, or D? We have more people to vote now. Hopefully your clickers are working. I know some had dead batteries today, so click away. 9, and I know more people have come in the room since we started this. Vote away, please participate. We're not tracking what your answers are for those of you who want to be anonymous. Okay. Let's see here. Oh, good, a variety of answers. Okay, let's go through these. Shortening the statute, A, shortening the statute of limitations by written agreement with an employee is illegal. Incorrect. You can do that. So think about that in terms of employment agreements that you have or things of that nature. Sometimes there can be issues related to it, but it is not per se illegal. B, no, it can't be dismissed because Susan did not need to file a charge because the activity arose before the effective date. Incorrect. It is based on when did she file her claim. So the fact that the discrimination occurred before the statute went into effect does not mean that she does not, if she's filing a claim today, have to file a charge. So, and she's got 2 years to do it from the time that the claim arose, so she's well within the window, but that's not a reason why it's going to be dismissed. We'll skip down to D. No, because an offer letter is not a formal agreement. Would an offer letter be a formal agreement? It's signed, it's in writing, it says, if you do this, I'll do that. It doesn't have to have the words contract on top of it in order to be a binding agreement. So D is not correct. C is the correct answer. And again, you have to have all the provisions, consideration, et cetera. You have to have an enforceable agreement, but you can shorten the statute of limitations via an agreement. Okay, a couple of other laws just to kind of keep your eyes on. This has to do, we are going to talk more about, sorry people, vaccination, and in this case, workers' compensation. 2 different bills in the House currently pending in Ohio. House Bill 401, employers have the potential to lose workers' compensation coverage for injuries resulting from a mandatory vax program. This is what's being proposed. It would create a new cause of action for employees who sustain injuries, again, as a result of a mandatory vaccination imposed by their employer. House Bill 435 is a bill that provides express coverage under the Workers' Comp Act for injuries or disabilities caused by mandated COVID-19 vaccine. Now, it'll be interesting to see if both of these pass the Ohio legislature, since they conflict with one another. But these are the sorts of things that are floating around in many states, is talking about how do we deal with workers' compensation coverage related to COVID-related issues, which would also include vaccinations, side effects of vaccinations, et cetera. Religious accommodations. Okay, this is the first of our hot topics. I will tell you, I've been practicing for 27 years. Prior to about a year ago, I think that I dealt with 3 religious accommodation related issues in 27 years. I think in the past week, I've dealt with more than 3. So everybody is becoming more familiar with religious accommodations. These cases are very interesting to me. And there's more out there like this. I just happened to pick these 3 because these are addressing issues that arose pre-COVID. Okay, so this is courts looking at religious accommodation issues without all the sort of, I'll say, politics related to masks, vaccination, all those sorts of issues. Okay, So EEOC versus Walmart, case out of the Seventh Circuit. Seventh Circuit is based in Chicago. This, for once, the Walmart actually won this case. Most of you know, usually when Walmart is involved, they end up losing. For whatever reason, I'm not saying anything about their counsel. I'm just saying they usually lose. And in this case, they did not lose. The court rejected, or in this case, the employer had rejected the claim from an assistant manager who said because of his religion, I think he was a Jehovah's Witness, he could not work from sundown Friday until sundown Saturday. And of course, Walmart has, you know, a lot of customers on the weekend, and they have shifts and schedules, and they put forward a very comprehensive explanation for why they could not accommodate and shift people around and have someone else cover every other weekend that this individual was supposed to work, et cetera, et cetera. And the court said, yeah, you know what? That's more than a slight burden, which is the standard for religious accommodation. Does it impose more than a slight burden? Slight burden is a really, really low standard. So many of you have called me in the past. We used to talk about ADA accommodations. That was our favorite thing to talk about in the accommodation realm. And we would talk about like, gosh, this is really going to impact employee morale because these people are going to have to cover for this person, or my other employees are going to have to do more work because this person can't be scheduled on Saturdays or what have you. And I would say like, gosh, that's really sad. Doesn't change anything. You have to accommodate under the ADA, because undue burden under the ADA is a much higher standard, particularly if you're a company like Walmart with gazillions of employees and gazillions of dollars in revenue. You're going to have a hard time saying, oh, this is such an undue burden to me. But when it comes to religious accommodations, if it's a slight burden, that is the current standard. Same thing happened in this case out of the Sixth Circuit, Small versus Memphis Power. Again, this is an individual who had the need to go to services on Wednesdays and also could not work on the Sabbath. In this case, the individual did engage in some conduct where he was told, he asked to have Good Friday off. He was told he couldn't have it off. He went and attended service anyway. So there was a little bit of sort of insubordination mixed in there. But again, what the court was looking at was, did this company, which had to provide sort of emergency coverage related to power lines being down or whatever, was it more than a slight burden for them to accommodate this religious request? And the answer was yes. Same thing with this D'Albertista versus GLE out of the 11th Circuit, which is, again, I would say maybe a more conservative circuit. Again, they were applying this slight burden standard, and again said, you know, this employee who now says, he didn't say it on his application, he said it after he was offered the job and knew that it was a 7-day-a-week job at times. They said, no, you don't have to accommodate that because that's more than a slight burden. Well, there are 3 justices who've sort of publicly, in different opinions that have been issued or with respect to cert petitions that have gone up, who have said they want to revisit this standard. Alito, Thomas, and Gorsuch have all said in opinions that they want to revisit this standard. They feel like it isn't fair because disability-related claims are being treated differently than religion-related claims. And so my guess is they're going to have an opportunity to do that, because all of you are probably dealing with religious accommodations in one way, shape, or form. And so some case is going to make its way up to the Supreme Court, and then we'll see what the current array of justices want to do about that. Mandatory vaccination. This is all going to be an issue near and dear to our heart at some point, probably. This is a case that came out from the Eastern District of Kentucky. Again, this is in the Sixth Circuit. Beckridge versus St. Elizabeth Medical Center. In this case, the court refused to enjoin the employer's mandatory vaccination policy. This is obviously a medical center, so it was arising in that context. You may be aware that some of the cases that were getting the most publicity in the beginning of employers mandating vaccination were healthcare organizations, hospitals, things like that. And those cases largely have said, you're free to tell your employees that they have to be vaccinated, subject to religious accommodations, ADA disability accommodations, et cetera. And that's true even of a case that came out of, I think it was University of Indiana, went up to the Supreme Court on sort of a preliminary review where they were requiring vaccination for students and teacher staff. And the US Supreme Court did not enjoin that mandate. So it's kind of interesting given what we know is going to go before the Supreme Court eventually here with the OSHA ETS. But this is a case where basically here in the Sixth Circuit, the district court judge said, listen, if you don't want to be vaccinated because of your personal, political, whatever reasons, that's all fine. Your choice in exercising your liberty is to walk away from your job. That was basically what he said in his opinion. So let's talk about this. So in this case, again, the plaintiffs were arguing that this mandate imposed upon their constitutional rights and failed to provide medical accommodations or religious accommodations, which was not the case. The evidence was to the contrary. The court, again, concluded, and it was a pretty strong opinion, that the plaintiffs had zero likelihood of success on the merits. The judge did not have to go that far. He could have just said it's unlikely, it's improbable, but he said zero likelihood chance of success on the merits. And again, this was a private hospital, so this was not a government actor, which takes it a little bit outside the realm of what we're going to be seeing with the OSHA ETS. The court focused on the Supreme Court case that you may have heard about. Again, if you're following these vaccination judicial issues, Jacobson versus Massachusetts, long time ago, 1905, a state imposed smallpox vaccination with the penalty of going to jail if you did not get the vaccine, upheld by the Supreme Court, however many 126 years ago. So that's a precedent that's been around a lot. I don't know how much it's been tested. It's been tested a little bit. But again, the court was looking at the balance of issues and saying, public interest versus individual liberties. And again, if an employee believes his or her individual liberties are more important than legally permissible conditions on his or her employment, that employee can and should choose to exercise another individual liberty, no less significant, the right to seek other employment. So I'm sure we'll see that quote in some other briefs that are filed on these issues in the coming days. Okay, very quickly, we're going to talk just a little bit about EEOC statistics. The lowest number of charges were filed in fiscal year 2020. The lowest since 1992. Now, I think a lot of that is COVID induced because the whole, workplace was just in a different place. So I don't really think that's necessarily going to be a trend we see. As is the case every year when I give you these statistics, over 50% of those charges include retaliation. Doesn't mean that's the only claim that is included, but over 50%. Those of you who deal with me on these issues all the time, I'm always telling you, it's not necessarily the crime, it's the cover-up. It's the same thing applies to discrimination claims. It's the reaction to the person raising the complaint that often gets you in much more trouble than the actual complaint itself. And then you can see the breakdown here, disability, race, sex, and age. LGBTQ, sorry, our letters are mixed up, steady, but I would expect that those types of claims will go up next year because there's going to be fallout from Bostock. So that's what we would expect. That's my prediction. You can come back to me next year and tell me if I'm wrong. Okay, OSHA ETS. Now we could spend an entire day on this issue, which we're not going to do. But I did feel like we needed to cover this to some degree because I'm getting questions about this every day, obviously. Okay, first of all, the OSHA ETS, which is the emergency temporary standard relating to masking, vaccination, and testing, applies to large employers. That's people who have 100 or more employees. They are required, and we're going to get to the litigation in a minute, so let's just assume that this goes into effect, or it is in effect. Let's assume that it actually becomes applicable and is being enforced. You must, if you're a large employer, require your employees to be vaccinated, or in the alternative, allow unvaccinated employees to test weekly and wear masks in the workplace. All right, it went into effect November 5th. And as most of you, I'm sure, know, lawsuits were filed within 5 seconds of it being issued. Most of the provisions of the ETS, again, barring an injunction and other legal issues, go into effect December 6th. That's a Monday. It used to be the 5th, now it's the 6th. Be aware, many people are sort of like, well, this doesn't really go into effect until January 4th. Untrue. Most of the provisions go into effect, barring an injunction, December 6th. Okay, we're going to talk a little bit about that. It will be in effect for 6 months. That's basically how it works with an emergency temporary standard, is that they can only be in effect for 6 months. What that means, many of you have talked to me about, hiring a vendor or having somebody engaged to provide testing to your employees, et cetera. The testing provision, which goes into effect January 4th, is 2 months into your 6-month window. So your testing obligation under the current standard would only be for 4 months. So when you're pricing this out and figuring it out, 4 months is really what you're potentially looking at. Are we covered? Okay, let's do a little hypo here. Julie is the head of HR at ABC Company. Her CEO has been reading about the ETS and wants to be certain that they are not covered. Julie pulls information from the HRIS system and finds that the company has 50 full-time employees, 40 part-time employees, 20 workers who are temps that were placed there by a staffing agency. ABC has also made plans to hire 20 workers for the holiday season, but they will be terminated on December 31st. Julie tells the CEO that ABC does not have to worry about the ETS because it doesn't become fully effective until January 4th, 2022. Is she right? A, yes. ABC will not have 100 employees on January 4th and therefore does not have to comply. B, yes. ABC does not include temporary employees, both staffing agency and seasonal employees. Or does not have to include the temporary employees, sorry. C, ABC only had 90 employees when the ETS went into effect on November 5th, if you count the full-time and part-time. Or D, no, ABC will be covered. I tried to keep the math simple, so hopefully. Chris has a question. Pardon me? They are not a federal contractor. Thank you for that clarification. Yes, they're just a regular old employee. Doesn't have to worry about the executive order. We're going to talk about that. This is just a regular old private company. So vote away. Thank you for that clarification, Chris. Keeping me on my toes. Appreciate it, as always. Okay. Chris used to be my associate, by the way. What'd you say? Oh, you were a partner too? No, I knew that. I'm just yanking your chain. Okay, because you're yanking my chain, I'm going to yank your chain. Okay. Oh, good. See, everybody's been doing their math and learning about the ETS. Okay, good. Okay, so let's go through this, the answers. The correct answer is no, ABC is going to be covered. We're going to talk a little bit about why that is the case. Let's start with the one that 2 of you voted for. ABC doesn't have to include temporary employees, meaning the staffing agency employees and seasonal employees. Part of that is correct. You don't have to include staffing agency employees. So if they are employees of the staffing agency who are placed with you, you're the host organization, you do not have to count them in your head count. If you are hiring people for the holidays or for the summer, well, the summer it won't be in effect, but if you're hiring people on a seasonal basis, they do go into your head count. Okay, so those people are included. So in this case, ABC has to count 50 full-time employees, 40 part-time employees, that's 90. And when they hire those 20 seasonal employees, they're at 110, they're covered by the ETS. Question A, answer A, nobody went for that because it's true. Once you are covered by the ETS, once you get to 100 or more, you're covered for the whole thing. Even if you say, oh, shoot, now we have 100, let's fire a couple of people and get ourselves back under that before it goes into effect. Too late. If you had 100 on November 5th and you just did a RIF last week, too late, you're covered by the ETS. Again, it doesn't matter if you had a certain number of employees on November 5th. The question is, if at any point during the ETS's effective period you had 100 or more, you are covered, okay? Most of you got that, that's good. Okay, how to count employees. Not by location. This was a question many people were trying to predict what the answer was going to be from the ETS. Would it be by location? It absolutely is not. So if you're operating 100 kiosks, little coffee stands with 2 people who work at each coffee stand, you are covered. So it's not by location. What if you have related corporate entities? OSHA is the one who's eventually going to decide this, at least on a preliminary enforcement basis. They have said they are focusing on, are you going to be a single employer? Basically, for OSHA purposes, they're going to look at, how do you handle safety issues? Do you have a single policy that applies to all of your LLCs that are sort of under an umbrella organization? Do you have a single safety director who responds to safety issues at 4 or 5 different business units that are different corporate entities or different LLCs? They might have different tax ID numbers, but are those sorts of issues being handled in some sort of uniform, consistent manner? OSHA is probably going to find that you are a single employer, and you better count your head counts in each of those organizations. And if you're over 100, you might want to plan on being covered by this. The default is going to be assume coverage. Like, let's be honest about what's going on here. OSHA, and I mean, you know, President Biden, OSHA, like, nobody is pretending like this is anything other than it is. They want people vaccinated. They kind of don't care how they get there. And one of the things that they're doing with this particular ETS is they actually want to make it easy for employers to say, you know what, everybody just get vaccinated. We're done screwing around with this. We're done fooling around. Everybody just get vaccinated, and then we'll be done with this. They want to make it easy for employers to come up with that policy, because that's going to result in a higher percentage of people being vaccinated. That's what they want. That's why employers do not, pursuant to the ETS, have to pay for tests. ETS says, hey, you don't have to do that. ETS says, hey, it's not up to us to decide whether or not you have to pay your employees while they're being tested. So they're saying, like, hey, that's all outside of our realm, and they want to make it as easy as possible for employers to be able to say, listen, it's not me, it's Joe Biden, it's OSHA making me do this, but I'm sorry, I'm going to have to ask everybody to get vaccinated. So that's really, obviously, that's what's going on here. Whether that comes into play, we're going to find out once all of our little circuit courts in the U.S. Supreme Court rules. But we do have an exception. If you are a federal government contractor or subcontractor with certain covered contracts, that's like a whole separate presentation, then you are subject to the executive order. Those employees are not subject to the ETS. Okay, so you might have 2 different regimes in your workplace, because some locations maybe are government contractor covered, and some are covered by the ETS. Same thing with healthcare workers that are covered under the ETS that was issued in June. They do not have to comply with sort of multiple standards. Okay, federal versus state OSHA. This is something, honestly, I've been doing this for a long time. I'm not an OSHA expert, didn't really focus on this, but there are a number of states that have their own state OSHA plan. What does that mean? What it means is it's going to be a little bit of a timing headache, potentially, if you're dealing with employees who are in multiple locations. The federal government has jurisdiction through OSHA over employers in 29 different states. So if you're in one of those states, OSHA ETS, whatever it means, whenever it's going to be enforced, whatever the courts say, that's going to apply to you. If you have operations in a state that has a state plan, the state is required within 30 days, so 30 days from November 5th, to come up with their own state plan that is at least as effective as the federal plan. Now, to add to the confusion here, some of those states have already said, yeah, we're not doing that. And so the question is going to be in those states that say, yeah, we're not interested in doing that. What's going to happen? Is their state plan going to get revoked and federal OSHA is going to be responsible there? Is there going to be some different standard? How is enforcement going to work? Can't answer any of those questions for you, unfortunately, but that is going to be an issue if you are in a state with a non-existent state plan. What is your obligation? And in particular, in those states, shouldn't come as a surprise, some of those states have provisions in place that say you cannot force your employees to be vaccinated. You cannot discriminate against unvaccinated employees. You cannot make people wear masks in certain circumstances. So there are going to be a lot of conflicting provisions that you're going to have to deal with. In general, if you're in the federal OSHA jurisdiction and the ETS is in effect, I would rely on the fact that federal law preempts And so federal OSHA is going to be your guiding principle in terms of your workplace, even if there is a conflicting state law in those particular states. Okay, the ETS litigation. Every day I get asked the question, what's going to happen? I'm going to be honest with you. I have no idea. The only thing I can tell you for sure is you're not going to know the answer to that question in time to start preparing if you wait until you get the answer to that question. So delay is not an option here. You have to think through what you're going to do depending on what comes out from the courts. In this case, today is lottery day, apparently. I never even knew there was a lottery among the circuit courts, but there is. When a standard like this is being challenged in multiple circuits around the country, they do a lottery for every circuit where a case has been filed. They put the circuit in a hat or whatever they do, and they're going to pick a circuit out, and that circuit is going to be the one to actually issue an opinion. Everybody's heard probably about the Fifth Circuit. The Fifth Circuit did issue an injunction literally within a couple of days of the ETS coming out, and then they reaffirmed it last Saturday, putting an injunction in place. It's unclear whether that injunction only applies to the Fifth Circuit, which is Texas, Louisiana, Mississippi, and I think a couple of other states, southern states covered by the Fifth Circuit. Unclear whether that injunction is a national injunction, unclear whether a circuit court in the Fifth Circuit can issue a national injunction. So there's a lot of, I would say, academic and esoteric questions related to that. But what is going to happen is some circuit is going to be picked from the hat, event we think today. Depending on what circuit that is, you can sort of start reading the tea leaves for potentially what may happen. But even once that circuit deals with the gazillion briefs that are going to be filed there and potentially deals with the Fifth Circuit injunction that is in place, eventually all of that is going to be appealed up to the US Supreme Court. And we will see what happens. Does all of it survive? Does some of it survive? Does none of it survive? All of those are potential options. The arguments among many that are being made in all the circuits, as far as I know, 10th Circuit is the only circuit where a case has not been filed. Could be wrong. I looked at that yesterday. Some of the issues that are being raised. The ETS does not address a grave danger. The pandemic is not a grave danger. But one of the things that's going to impact that assessment, I think, is that the number of cases are going down and the number of vaccinations are going up. So whether it was a grave danger 6 months ago, how does that compare to, is it a grave danger now? Going to be interesting. There's an argument, COVID is not the type of substance, agent, or hazard that can support the issuance of an ETS. The ETS is not necessary. This is a standard that has to be met in order to do an emergency temporary standard. I never took administrative law, probably should have in law school. I'm regretting it now, except that I've heard that that class was extremely boring. So I had 27 years where I didn't care. So I'm probably coming out ahead. But anyway, there is a very specific procedure that you have that an agency has to go through to promulgate regulations. And obviously, when something is an emergency temporary standard, they don't go through that process. They don't get comments from the public, et cetera. And so there's sort of a higher standard applied to say, wait a second, you didn't really go through kind of what we'll call the regular process. So we got to make sure that this actually meets the standard for being an emergency temporary standard. Again, no public comment, although there is a public comment period right now, and an argument that the power to compel vaccinations rests with the states and not the federal government. I think this is a sort of, check off for, gosh, we have a Supreme Court precedent that said a state can require you to get a smallpox vaccine or send you to jail. So how are we going to deal with that? We'll deal with it by saying, well, states can do that, but the federal government can't. So we'll see what happens with those arguments. Again, talk to you a little bit about who's ultimately going to decide this. It's a circuit court chosen by lottery. Again, today, we'll see if it comes out today, somebody tell me what they see on their feed, and then we'll do some predictions about what that circuit may do. But this timing really puts pressure on employers. Okay, hi, Julia. Good morning. I'm a little bit behind, but I'll move it along. Oh my goodness. Okay. Gosh, she's so demanding. Okay. Paying for time for testing. We are expecting that the Department of Labor is actually going to issue some guidance with respect to whether or not you have to pay employees to go get tests, if in fact that's what you choose as your option as part of your plan. If the employees are coming on site and you're testing, before they start their shift on Monday or on their lunch break or whatever, I would strongly suggest that that is paid time. So compensable time. If they're doing this on their own, on the evening, after hours, the question that the FLSA will be asking is it necessary to perform their job safely and effectively? This ETS is in place. I think it's a pretty hard argument to say that that's not the case and that it should not be compensable, but hopefully the Wage and Hour Division is going to provide some guidance for this. Another issue is, so the ETS says you don't have to pay for time, but they said, check other laws because we're not the authority on this. So you have state laws that you have to look at. You have your collective bargaining agreement. Those things may compel you to pay even if the ETS doesn't. Is this an accommodation? Are you doing testing because someone has a religious or medical objection to vaccination? If it's an accommodation, you probably have the obligation to pay for the test, the expense of the test. Julia can talk to you about all the issues related to whether this is a plan, whether this can be part of your EAP, et cetera, and whether you have benefits issues that arise from this. But if it's an accommodation, you probably should be paying for it. You need to think about if you have workers who are being paid minimum wage or close to minimum wage, and they have to pay for a test every week that costs $20, $30, $40, $50, $60, are they now being compensated at minimum wage? Are they working more than 40 hours? They're working 40 hours at the plant, and then it takes them 2 hours to get their test on the weekend. Do you have an overtime issue? Are you paying them less than minimum wage when you take their pay and divide it by the number of hours they are working? So there's a lot of issues there to be thinking about. There are state laws that talk about medical tests being something the employer has to pay for. There are state laws that talk about those issues. They're really kind of talking about them in the context of you're hiring the person and they have to have some sort of like physical or ability to do their work test, and that has to be paid for by employers. Will that apply to COVID testing that they have to do every week? I can't tell you for sure, but there's a lot of state issues in terms of state law requirements. You have significant documentation requirements that become enforceable, subject to injunctions, December 6th. If you listen to my webinar for Path Out of the Pandemic, when Joe Biden initially announced all of this stuff was coming, I told you at that time, figure out how many of your employees are vaccinated, because everything you do is going to be driven by, are we talking about 5% of your population? Are we talking about 40% of your population? What is your access to tests? Are these people who are going to have some sort of accommodation request, or are they not? These are all questions you can get your arms around now. You frankly should have gotten your arms around maybe a couple months ago, but I'm not going to make you feel bad. But now is the time to actually be figuring those things out, because your roster of employees, vaccinated, partially vaccinated, not vaccinated, accommodation, that's all due December 6th. And if we get a ruling from the court on December 4th, it's going to still be in effect. December 6th, you're going to have that. So if you haven't started, there's still time. I can help you. Call me. I will help you get through it. Okay, quickly. Sorry, Julia. Accommodations. Medical and religious. We talked a little bit about the landscape with respect to religious accommodations. The standard is lower for undue burden. Most of you are probably pretty familiar with medical accommodations. This is like your standard ADA process that you go through, get the certification from the medical provider, figure out what the accommodation is, et cetera. These are all confidential medical records. They need to be kept in a separate file, separate database, shared need to know, all of those things that you're used to. We'll do a quick quiz question. Darren is an employee with XYZ. He's been telling anyone who would listen to him for the past year he's not getting the vaccine. He believes it is a ploy by the Democratic Party to change his DNA and make him a liberal. XYZ, I wish this were a joke, but this isn't, okay? XYZ has just mandated the vaccine, and Darren applies for religious accommodation. He tells HR it is his God-given right to make his own medical decisions, and his sincerely held religious beliefs do not permit him to be vaccinated. XYZ asks for a letter or documentation of this belief that Darren fails to provide because he doesn't belong to a formal church. Okay, should XYZ excuse him from vaccination?
Yes, Darren has said that this is his religious belief, and employers have no grounds for questioning an employee's belief. B, no, Darren clearly has a personal political belief that's not dictated by religion. C, no, if Darren fails to demonstrate that the objection is based on a sincerely held religious belief. D, no, Darren has not provided supporting documentation from an outside party so the accommodation can be denied. So vote away. Julia, did you vote? Okay, I hope you got it right. Okay, I like to tease you. Oh, wow, very good. I mean, people have become religious accommodation experts. It's amazing. Okay, we'll talk about, and I'm not gonna, I don't wanna pick on the people. Some people maybe gave these answers so that we could talk about the wrong answers, and I appreciate that. So C is the correct answer. D, no, because he hasn't provided documentation from an outside party. You can have a religion of one. The Nancy Barnes religion can be officially recognized. So you do not have to have a letter from a rabbi, a priest, a minister. You do not have to have that. So one is incorrect. A, he said that his, okay, no grounds for questioning an employee's belief. You are allowed to question their beliefs. You're allowed to ask questions about this to determine, is this sincerely held? So you can probe that. It has to be done carefully, but you are allowed to probe that. He clearly has a personal or political belief. I would say yes, he does have a personal political belief, but he might also have a religious belief. I don't think God-given right is a religious belief, but if you continue to probe that, you may find that there is a religious belief there that would support an accommodation. So again, doesn't have to be a traditional recognized religion. I've never heard of that church. I've never heard of that faith. Doesn't matter. You don't have to have heard of it. That's not going to be the standard. But if it is something that's personal, it's political, it's social, then that's not something that has to be accommodated. These are in your materials. I'm not going to go through all these bullet points because Julia will be mad at me. Am I allowed to do my follow-up quiz question? Thank you. Okay. They want to listen to me. Yeah, sit down. I'll call you up when I'm done. Okay. XYZ determines that it's not going to challenge his sincerely held religious belief. It then begins to consider accommodations. Darren cannot work at home and must be in the workplace. Darren has told his supervisor that he's willing to test weekly, but because that's a religious accommodation, XYZ must pay for it. XYZ has approved religious objections for about 25% of its employees and is facing a significant weekly cost to test those employees and track results. Therefore, it rejects Darren's request and places him on indefinite unpaid leave. Can they take that action? Yes. XYZ is faced with a significant cost and can deny the accommodation on that basis. B, no, XYZ is in a better position than the employee to bear the cost of the test. C, no, XYZ cannot make a decision that imposes a cost on an employee, i.e. unpaid leave due to religion. Or D, yes, if XYZ still has doubts that this is truly religious. Okay. Vote quickly because Julia's giving me the dirty looks into her time. Okay. Any more votes? Okay. Okay. Okay, I'm glad nobody went with B, that XYZ is in a better position. That's not the test. Who can better pay for the accommodation? That's not the standard. Can XYZ take that action? No, because answer C, because it imposes a cost on the employee. You're actually allowed to impose a cost on the employee. Remember, slight burden for the employer is a reason that they can say, yeah, we can't do this, and so we're not going to be paying for the test. If they have to pay for the test for 25% of their workforce, they may have a very good argument that that is not an accommodation they have to provide for a religious reason. XYZ still has doubts that this is truly religious. That has to go back to step number one. Are you saying that they have a sincerely held religious belief? Either yes or no. Once you say, well, yes, or we're going to accept that, then you're into accommodation mode and you have to think about accommodation. So the correct answer is A, they are faced with significant costs. That was kind of built into the premise. And so they can deny, again, remember that slight standard for religious accommodation, they can deny it on that basis. Okay, whoops. Okay. testing and logistics and supplies, I'm going quickly. Very quickly, OSHA has said that it doesn't see that there's going to be any problem with testing supplies. So for those of you who are worried about that, I mean, honestly, I don't know what you're thinking. Yeah, there's going to be a testing issue. So here's the thing. If you are using testing and you don't have testing supplies, the lab's backed up, whatever it is that may happen if this gets implemented, document, document, document. Good faith efforts are going to get you a long way. But if you don't have documentation of what you tried to do to address this issue, that's potentially going to be a problem. Quick practical tips, last 2 slides. Okay, do not wait for the pending litigation to be resolved before you start making plans. I mean, seriously, if you have not already started, please start as soon as you leave the building. How many of your employees are vaccinated? Find that out. That is going to help drive your decision making. Are you doing mandatory testing? Are you going to have a mandatory vaccination? Are you going to have a testing option? Obviously, this depends on the demographics of your workforce, your recruiting and retention issues, availability of tests, key talent. I mean, there's a lot of things that go into this from a business perspective. Proactively communicate with your employees. You probably can't avoid this. You're probably getting calls from them about what are we doing? What are you going to make me do? Start drafting your policies and think through what are you going to do disciplinary wise for people who don't comply. You will have people who will not comply. So are you firing them? Are you suspending them? Are you giving them a cooling off period so they can really think about it before you fire them? I mean, you have to think through those issues. Last thing, designate a compliance person. If you're attending this presentation, it's probably you. Make a testing plan. Again, start talking to vendors if you're going to try to do this in-house. Figure out how you are going to deal with the logistics of this and how you're going to store this information. That's very, very important. Accommodation process. Consistency, having the same people looking at all of the religious accommodation requests so that if you're approving because somebody says this is made from stem cells or fetal materials or whatever, if you approve one person because that's their religious objection, then everybody who's saying that, and believe me, you're going to see a lot of similarities in the religious objections, then everybody should be approved. So you want to have some consistency there. Train your supervisors and managers. If you have to share information with them because they're in charge of enforcing the masking rules, so they have to know who's unvaccinated and who's not, and who's vaccinated, then you need to share with them. That's not to be shared with other people. That is something that is on a need to know basis. You're a manager. That's the only reason you need to know, and that's why we're telling you. And again, do your employees know what to do if OSHA's at the door? Many of you work in workplaces where you've never encountered an OSHA agent in your life, probably because you're not in a manufacturing facility, you're not on a construction site. But OSHA's going to be knocking on everyone's door or calling you and asking for your records in 4 hours, which is the standard. So to those of you who think like, oh my gosh, like how in the world would I ever get these records together in 4 hours? That's one of the questions you should definitely be thinking about. So, and if you haven't trained your managers on what to do when OSHA shows up, that's something else to be starting to think about over the next few weeks. Okay, questions? I'm not going to let you, I'll let Monica answer what, can Monica ask a question? Okay, thank you.
Sorry, Julia. If you are, I guess this is 2 questions. If you're
Oh.
hovering around mid-90s for employees, should you just comply? And do you feel like there might be another emergency order for all employers?
Okay, good question. So if you're hovering around 95 or so, should you just go ahead and comply? It's really a business decision. I mean, in terms of just complying with what is currently the OSHA ETS, if you're not going to go above 95 and you have some control over that, then you're not going to be covered by this ETS. And so if that's creating a ton of issues and costs and logistics, then, you know, it certainly makes sense to say, well, we're not covered by that, so we don't have to comply. We're going to do whatever we're going to do in terms of what we want to do as a corporate culture, et cetera. Is there eventually going to be a rule that covers everybody? I'm going to say probably yes, because one of the arguments that's being made at this current Circuit Court Appeals is, wait a second, why is this so dangerous for a workplace with 100 employees, but it's not dangerous for a workplace with 99 employees? That doesn't make any sense. That makes it arbitrary. So at some point, if that becomes a very compelling argument, they'll say like, oh, okay, well, let's just get rid of the 100. It covers everybody, or it covers everybody who comes into a workplace. So I would expect that eventually, but I think that's pretty far down the road. Okay, I'm going to turn it over to Julia because I don't want her to be mad at me. For those of you who are on the phone or on the webinar, the CLE you have to put, the code you have to put for this portion of the presentation, TH1116, the letter A. TH, Thompson Hine, 1116A. Thank you very much. I'll turn it over to my partner, Julia Love, who is a partner in our employee benefits group here in Cleveland.
Or do I have to move the slides too? This is like a three-ring circus. So good morning, everyone. As Nancy said, my name is Julia Love, and I'm a partner here in the Cleveland office of Thompson Hine. I'm also the practice group leader of our employee benefits and executive compensation practice group. I am going to be discussing this morning some hot topics in employee benefits. I feel like Nancy already previewed a little bit of that. First and foremost on everyone's mind, we're going to talk about employee benefits issues related to testing and COVID-19 vaccines, and also incentives and surcharges for COVID-19 vaccines. And I'm also going to talk about some year-end amendments for health and welfare plans and also retirement plans. And then for those of you here in person, you're going to get to see me again this afternoon. I'll be presenting with two of our associates, Mark Kroboth and David Eulendorf, on other employee benefits issues. So let's get started with COVID-19 vaccines. As you likely know, if you sponsor or if your employer sponsors a group health plan, group health plans are required to cover the cost of COVID-19 vaccines and the administrative charge relating to COVID-19 vaccines. And we found out earlier this year from the IRS through their implementation FAQ number 50 that you have to provide coverage for the vaccine immediately upon the particular vaccine becoming authorized. And that includes authorization for booster shots and also for additional individuals becoming eligible for COVID-19 vaccines. But what if you want to cover employees who are not, or if you want to provide vaccines for employees who are not covered by your group health plan? Is there anything that you can do to do that? And I'll note that the slides are written as if we're only talking about vaccines, but the same analysis also applies for COVID-19 testing. So the regulators told us earlier this year that if you provide COVID-19 vaccines or COVID-19 testing for employees who are not part of your group health plan, one way you can do that is through a COVID-19 either testing or vaccine program EAP. And that would not cause that EAP to lose its accepted benefit status. And that's a really good thing because that would mean that you're not required to satisfy the market reform provisions of the Affordable Care Act, which is, if you have sponsored a group health plan, that's a pretty heavy lift. That would require coverage of all preventive care services. It would require lifetime limits. It would require coverage of essential health benefits. So this is a great thing if you can do it. So if you want to cover vaccines or testing for your employees without creating, a group health plan that's subject to the Affordable Care Act requirements, an EAP is definitely the way to go. You could also provide your COVID-19 testing or vaccinations through an on-site medical clinic. But does providing the COVID-19 vaccine or testing outside of the medical plan create a new ERISA group health plan? And I think the answer really turns on a couple of things. One, is it providing medical care? And I think almost everyone would argue that providing a vaccine or providing testing is some kind of medical care. And then the second requirement is that there's an administrative scheme. So I had this question posed to me earlier, or last week, I guess. What if we just put a bunch of COVID tests in our break room or in the coffee room or whatever, and people can test themselves, whatever? More than likely, that's not requiring any kind of administrative scheme. I don't know how you would work that with the ETS. Somebody has to proctor that exam, but presumably if you give them the test and they find some provider that's going to proctor it, that's not the employer, maybe that's not a group health plan. But if you're going to proctor the exams or you're going to engage a third party to proctor the exams on behalf of the employer or provide the COVID vaccines on behalf of the employer, more than likely that's an administrative scheme and subjects you to the group health plan requirements of ERISA. But remember, I just said it's an accepted benefits EAP, so it's not subject to the market reform provisions of the Affordable Care Act. So that's, again, a really good thing. So our first polling question, and I apologize, my questions aren't as fun as Nancy's, but are group health plans required to pay the cost of COVID-19 vaccines? Yes, subject to the plan's cost sharing provisions. Yes, but only the portion that the provider charges and as administrative fee. Yes, 100% of the cost of the vaccine and the provider's administrative fee, or yes, but only if the plan has been amended to provide coverage. And I forget, do I have to push the button to see?
No, they're polling now.
Okay.
And then once you push the button, they'll close the poll.
Okay, so vote, vote, vote. Okay, so let's talk through why A and D are not the correct answer. So the regulations, the guidance, the COVID-19 guidance that has come out essentially says that while we have the COVID-19 national emergency, group health plans are required to cover the cost of vaccination 100% with no cost sharing. So A obviously violates that. And D is not correct either because, like I just said, regardless of whether you amend your plan or not, you have an obligation for the plan, if it is a group health plan subject to ERISA, to provide COVID-19 vaccines at 100% with no cost sharing. And I'll just note that's in and out of network. And it intentionally, the regulators provided that because in some areas, there was a possibility that an in-network provider wouldn't be available to provide vaccines, and we're obviously incentivizing people to get vaccinated as easily as possible. So C is the correct answer. So now I'm going to turn to, can you incentivize people to get COVID vaccines? And really this turns on a couple of things. One, is the incentive available solely for purposes of, or is the incentive available solely if you show the employer the vaccine card? Or are you requiring employees to have the vaccine administered by the employer? And will the group health plan be, or will the incentive be part of the group health plan? In other words, will you provide a premium surcharge or a premium discount if employees show their vaccination cards? So we're going to walk through a couple of examples. Oops, I'm going the wrong way. Well, whatever. The first is that the employer provides a gift card if the employee simply shows proof of vaccine administration. So in this case, we know the group health plan is not involved. Therefore, the HIPAA non-discrimination rules applicable to wellness programs are not implicated. And we're not asking the employees to undergo a medical examination because the EEOC has told us that it's not, getting a vaccine is not a medical exam under the ADA requirements. And you're just asking people to show proof of the vaccine. You're not asking them to disclose any medical information, disability related or otherwise. So basically, yes, you can provide a gift card to employees for simply showing their vaccine card. It's taxable. Everything's taxable. Income is income from whatever source derived. That was, I think I learned that on day one of law school. The second example, the employer, instead of providing a gift card, is going to provide cash to the employee if they get a vaccine that's administered by the employer. So again, in this example, the group health plan's not involved, so you don't have any HIPAA non-discrimination wellness program requirements that you have to comply with. But in this case, more than likely, the pre-screening questions that a employee has to undergo in order to get the vaccine would rise to the level of a disability-related inquiry. So more than likely, the EEOC wellness regulations, which are under the ADA, would come into play. And we're going to talk in a minute what the HIPAA non-discrimination rules relating to wellness programs are. And essentially, the ADA requirements follow that same regime, more or less. But you may recall in 2016, there was a lawsuit, AARP versus EEOC, that vacated the statutory safe harbor for rewards under the ADA for voluntary wellness programs. So we really don't have a threshold reward that you can provide or surcharge that you can charge that would qualify a wellness program as either voluntary or involuntary. So I guess buyer beware there. And then our last example, as you probably can guess, is, now we're going to charge a surcharge for an employee who is a participant in the health plan who does not have a vaccine. And what does that mean? Well, earlier this year, the regulators told us that a vaccine surcharge program is a health contingent wellness program. And you may recall that there's two different types of health contingent wellness programs: activity only or participatory or outcomes based, sorry. And this type of wellness program is activity only. So what does that mean? It means that you're limited in the amount of incentive or surcharge that you can provide, and the amount of the incentive is limited to 30% of the lowest cost single only tier of coverage that the employer provides. So it's 30% of that amount. Nothing is ever easy in the employee benefits area, so remember that you can increase that incentive limit up to 50% of the total costs of single only, the lowest cost option, single only coverage that the employer provides if you have a tobacco incentive as well. And you also have to provide a reasonable alternative or a waiver for individuals who cannot get the vaccine, either because it's medically inadvisable or unreasonably difficult due to a medical condition. So an example of a reasonable alternative would be that the employee attests to complying with the COVID-19 vaccine, the COVID-19 masking requirements for unvaccinated individuals. And I think query, how is the employer going to monitor that? I mean, you certainly could monitor it in the workforce, but I don't know how you'd monitor it in life, so I don't know that, whatever, anyway. You also have to, as part of the HIPAA non-discrimination rules, if you require a reasonable alternative, you could also require that the individual provide some medical documentation as to why the vaccine requirement is unreasonably difficult or medically inadvisable. But if you do that, then you also have to take a personal physician's basically word for it that the reasonable alternative that you're providing is also not acceptable to this individual employee, and you would have to accommodate the recommendations of the personal physician. Also, any materials that you provide relating to the wellness program or your group health plan, premiums and incentives and discounts, things like that, would have to describe the reasonable alternative and also provide contact information for getting the reasonable alternative, and also that you would accommodate the recommendations of the employee's personal physician. And lastly, your wellness program has to be reasonably designed to promote health and prevent disease. I don't think that would be a problem with a vaccine surcharge or incentive. The program cannot be overly burdensome, and the reasonable alternative can't be overly burdensome or must be designed to prevent infection or spread of COVID-19. And you have to give employees the opportunity to earn the reward at least once per year, which some people think may be an issue with COVID-19 vaccines, because once you're vaccinated, like, what do you do next year to get the same reward? Or maybe you wouldn't give the same reward next year. And lastly, I wanted to point out that if you are going to have a vaccine surcharge or a vaccine incentive tied to your group health plan, remember that you have to take that amount into consideration when you determine whether the plan is affordable for purposes of the Affordable Care Act. And for employers that have 100 or more employees, you have to report to the IRS on your 1095Cs whether your group health plan is affordable or not. And the way that you do that is it's a percentage. For 2021, it's 9.5% of either the employee's W-2 earnings for the year, the federal poverty limit for the year, and the other one is the employee's rate of pay. So you can choose which safe harbor you're going to use, but the lowest cost premium for single only coverage cannot exceed that 9.5% of the premium amount. And you'll see at the bottom of the slide there's an asterisk that's going to be adjusted for 2022 to 9.61%. And when determining the premium amount, you have to include the value of the incentive that you're offering for vaccinations or non-vax, the surcharge for people who are not vaccinated as part of that premium cost. And I know we've worked with a lot of employers who already have wellness programs in place and already bumping up into that limit. So it was problematic if they were going to charge an additional, premium and surcharge or incentive to as part of their wellness program. But I'll note on the slide here, you'll also see we have a tobacco surcharge of $75 that's not taken into account. And that's because when the Affordable Care Act was enacted and they bumped up the limits, it used to be 20% for non-tobacco related programs and 50% for tobacco or nothing for tobacco related programs. The ACA increased the limit to 30% for non-tobacco related programs and then added the 50% for tobacco related programs. They want people to quit smoking. So they're saying, we're going to allow you to determine your affordability standard as if everybody earns the reward for not smoking. So what's an employer to do? If you're going to pay for vaccines, if you're going to pay for testing, either as part of the ETS or otherwise, the first thing you want to do is determine whether the way you're doing it is a ERISA plan. So remember, it's an ERISA plan if it provides medical coverage and there's an administrative scheme. What does it mean if you're an ERISA plan? It means you have to comply with ERISA, COBRA, and HIPAA. For ERISA purposes, you need a plan document, you need a summary plan description, you need claims and appeals procedures, and if you have more than 100 employees, you need to file a Form 5500. Most employers, this isn't that big of a deal because you already have, hopefully, some sort of plan document, and if you already have benefits that are available to all employees, regardless of whether they make an election, like an EAP or an employee assistance program, you've already got that framework in place. Slap an amendment on the back, here's what we're doing for COVID-19 testing, here's what we're doing for COVID-19 vaccines, boom, you're satisfied with the requirements. COBRA, employers are getting wrapped around the axle on this one, and I can understand. Why on earth would you provide continuation coverage for an employee to get COVID-19 testing after they've left your employment? It's just the way the law is, right? Your congressman. I can't tell you why. But I think it's really not much, I don't think you really need to worry about it. Most employees that are subject to or weekly testing are not going to be dying to come into your workplace and get a weekly test. The only time I can think of it might be an issue is if, Monica's paying for weekly testing at the Cleveland Foundation and an employee leaves and goes next door to another entity that also allows weekly testing but's not paying for it. It's pretty easy to come and get it from Monica, and then go work at the other employer. But I think those situations are few and far between. But you can somewhat get around it. If you're already providing COBRA continuation coverage for your EAP for all employees who are enrolled in the EAP, and you're not having them make an election or pay for the COBRA continuation coverage, then just put in your communications, this benefit's subject to COBRA. I hate to say it, nobody reads that stuff anyway, and there's not a lot of, nobody wants this benefit, so don't worry about it. If you're worried about people taking COBRA, then send your COBRA notice and election and charge a premium. That will dissuade people also from taking advantage of your program. If you have questions, feel free to call Nancy. She'll handle it.
Oh my God.
And lastly, HIPAA. As you may know, HIPAA prevents the disclosure of protected health information to the employee without either a waiver from the employee or if the employee provides it directly to the employer. So if you're, for example, administering a COVID-19 testing program on site by a third-party provider, have the provider require the employee to sign a waiver at the time they get the test that the third-party provider can provide the results to the employer, or the third-party provider provides the results to the employee and the employee provides it to the employer. Boom, HIPAA's taken care of. The other thing I want to note, a lot of employers offer flu shots on site for their employees for convenience and to ensure that their employees are getting protected from the flu. The same analysis applies for flu shots as applies to COVID-19 testing and vaccines. I think for the most part, most employers have just not worried about this, and it's low enforcement from the regulators, but there may be more scrutiny in light of these new programs popping up for testing and vaccinations. And then finally, if you're going to be providing incentives or surcharges for vaccination status, remember that you have to comply with the applicable requirements, as I mentioned earlier, based on whether it's part of the group health plan, whether the employer is making a disability-related inquiry. Okay, this one's easy. Is your organization considering a vaccine mandate? Yes, we already have a vaccine mandate. We are considering a vaccine mandate. We are considering a vaccine mandate with a testing alternative, or we haven't decided what to do. Are we good?
Oh, I voted yes, thank you for
Okay.
asking.
Okay, well, we're all over the place. I'm really not surprised that people or employers haven't decided what to do. Nancy just got done talking about the ETS. Lots of things are up in the air. It's also, of course, horrible timing for employers to try to decide what to do with their group health plan incentives because we're already either done with open enrollment, in the middle of the open enrollment. There's just a lot to consider. For those 2 people in the audience that already have a vaccine mandate, good for you. If you have questions, obviously call Nancy. Okay, the last thing I'm going to cover this morning is some year-end amendments for health and welfare plans and retirement plans. This slide lists a whole lot of changes that were implemented as a result of various pieces of COVID-19 guidance that came out in 2020 and 2021 relating to cafeteria plan amendments. And the whole point of the guidance was normally cafeteria plans require that employees make elections prior to the beginning of the plan year, and those elections have to stay in place for the entire plan year unless an employee has a change in family status. Who knew in October, November of 2019, when you were making your annual elections for your cafeteria plan, that we were going to have a pandemic starting in February, March, whatever, of 2020? So you may have put money in your flexible spending account for dependent care expenses or for medical expenses, and you couldn't use that money because daycares were closed, doctor's offices were closed, you didn't feel comfortable going to the doctor, whatever. So the regulators are aware of this and put in a plethora of opportunities for employers to make changes to their plans to benefit their employees. So for example, in the 2020 plan year, you could have allowed people to make a mid-year change to their elections to reduce their healthcare spending account or their dependent care spending account, or opt into medical plan coverage when they'd otherwise opt out, or change the level of medical plan coverage that they had. If you did that, now is the time to make an amendment. The amendments are required by December 31st, 2021. Normally, cafeteria plan amendments like that would have been required before the beginning of the plan year. So this is a gift. So if you made changes, you want to document them now. There's also, like I said, tons of relief reflected on this slide. So lots of employers extended the grace period for their flexible spending accounts. So normally you have, money you put away in 2019 had to be used by March 15th, 2020. You could have extended that grace period to the end of the year. Now is the time to make the amendment. You could change from a grace period to a carryover. So grace period gives you longer to use the money. Carryover actually moves the money into the next year. You could use it. Anyway, lots of changes. Again, if you made changes in 2019, well, not in 2019, but if you made changes in 2020 or 2021, think about, based on this chart, whether you have amendments that are due now. Also, if you make changes in 2021, at the end of the chart, you'll see you have until the end of 2022 to make those changes. A couple of other group health plan things to keep in mind. One is that during the COVID-19, early days of the COVID-19 pandemic, lots of physicians were offering telehealth visits, and most people, I think, thought it was safer to have a telehealth visit for something that could be dealt with through telehealth. And the regulators provided that a high deductible health plan could cover the cost of telehealth services at no cost, with no cost sharing before the deductible was satisfied, which is normally a no-no under a high deductible health plan. That guidance is sunsetting as of December 31st, 2021. So if your employees are used to now having telehealth visits covered at no cost sharing, you might want to let them know that that's ending at the end of December of this year, and that for 2022, they're going to have to pay for it until they've satisfied their deductible. The other thing, the last bullet on this slide that has been a major headache for most clients that I work with are these COVID-19 benefit deadline extensions, primarily because they're hard to understand and most employees are not taking advantage of them, but regardless, they are the law. So back in April of 2020, the Department of Labor, with consensus by the IRS or the Department of Treasury, issued these deadline extensions, which apply to HIPAA special enrollment rights, COBRA election payment and notice rights, and claims and appeals deadlines, which basically extend the deadline or provide a tolling period of deadlines for up to 1 year after the date the deadline would have otherwise occurred, or if earlier, until 60 days after the announced end of the COVID-19 national emergency. Well, I don't think at the time anyone thought the national emergency would go beyond a year, and the statutory authority for the Department of Labor and the Department of Treasury to extend deadlines is 1 year. So when this, and oh, by the way, when they announced these deadline extensions in April of 2020, they made them effective as of March 1st, 2020. So when February 28th was rolling around, I think a lot of people were scratching their head, what's going to happen to these deadline extensions? I think if you had asked me on February 26th what I thought was going to happen, I would have said they're going to just say that these deadline extensions are over. Nobody's using them. They're difficult to administer. They're hard to communicate. But no, that's not what they did. Instead, they said every deadline has its own extension. So if I'm going to pick on Monica, or I could pick on Chris. There's only 2 people I recognize with their masks on. So Chris has a qualifying event, on April 15th of 2020. Normally, he would have to make his COBRA election within 45 days of receiving, or within 60 days of receiving the notice, and then payment within 45 days after he makes his COBRA election. Each one of those individual deadlines is extended either for a year or for whatever the period you have to make an election or payment, plus 60 days, plus the end of the COVID-19 national emergency. And then just a couple of weeks ago, or maybe a month ago now, the IRS came out and said, well, but that's really hard. So the payment and the election deadlines are going to run simultaneously. So there's even more complicated rules. So I think call your benefits lawyer if you have questions about those. Another thing to note with regard to retirement plans, and this applies to 401k and 403b plans, if you have hardship distributions available under your plan, you are required to adopt an amendment to your plan no later than December 31st, 2021 that implements the required administrative changes for hardship distributions. And also, there is an extended benefit deadline, amendment adoption deadline for collectively bargained plans. You are required to use a market rate of return for hybrid plans, and collectively bargained plans that have a calendar year are required to adopt the amendment by December 31st, 2021. If you're a non-calendar year plan, it's the last day of the 2021 plan year. Benefits is a gift that keeps on giving. Prior to the pandemic, the regulators, or the Congress, I guess, adopted the Secure Act, which would allow an employer to implement a safe harbor non-elective contribution to your defined contribution plan at any time prior to the end of a plan year at a minimum amount of 4%. And the reason that this was deemed a good thing is because employers can't predict, if they have kind of variable earnings or whatever, whether they're going to be able to make a contribution or not. And this allows them to make a contribution at the very end of the plan year, for pay earned during the entire plan year, which is a good thing for employees. Well, then the pandemic hit and they said, well, that's not good enough. Employers are really volatile right now. We don't know, if somebody could make a 4% non-elective contribution at the end of the year. So for the 2021 plan year, you could adopt as late as 30 days before the end of the 2021 plan year to have a non-elective contribution of 3%, as long as you do it at least 30 days before the end of the plan year. So if that's something you're thinking about, act quickly. In general, safe harbor plans cannot be amended during the year unless a specific exemption applies or exception applies, which would include reducing or suspending your safe harbor contributions, establishing a Roth contribution, or as otherwise put forth in the regulations. So if you have a safe harbor plan or you want to implement a safe harbor plan, now's the time to do it before the end of the year. Otherwise, if you have a non-safe harbor plan, generally amendments that are implemented during a plan year can be adopted by the last day of the plan year. So again, if anything changed during 2021, you want to make the amendments now before the end of the plan year. And that's it. Thank you very much.
Hi, everybody. Welcome back. It is about 10:20. We're going to go ahead and get started. I think that they're rebooting the camera or something for those of you who are on the webinar. So fear not, it's gonna come back so you can see us. I forgot to give you the code for those who are on the webinar. Segment 2 code, Julia's presentation, TH 1116B as in boy. So if you're online, TH 1116B as in boy. I'm now going to turn it over to my partner, Glianny Fagundo, who is a new partner in our Atlanta office. She joined us in April, and she's going to be talking to you about diversity, equity, and inclusion. Glianny.
Thank you. Good morning, everybody. Excited to be here, especially since there were flurries waiting for me last night when I landed after a gorgeous 65-degree weather in Atlanta the day before. So I'm a little bit resentful about that. But Nancy, to make up for it, gave me a good time slot, which is not the first one. It's not the one right before lunch. So hopefully people are engaged. When we were putting together this seminar, we were talking about what are the hot topics for this year. And right around that time, I had a client call me and say, do you mind coming over here and explaining to us this whole diversity, equity, and inclusion thing? Because honestly, we think it's the same thing and we don't understand it. And it started making me think about it. And it was like, you know what? We have been talking a lot about that in this past year. You know, we moved on from BLM, we moved on from #MeToo, and now everybody wants DEI. And even the companies who had a DI officer now are wondering what happened to the E. Should they add the E? What is this E? So I thought it was actually a good time to talk about it. And as I was creating the presentation, a great case came down, not necessarily great in that things are going to get easier for companies, but in that it brings this to the forefront of what it is that companies are doing with these plans, with this DEI thing, right? And we're hearing about compensation for CEOs being tied to diversity targets. Can we do that? So we'll talk a little bit about that. And before we get into that case that came down, I wanted to, if everybody can indulge me in this small exercise, and that is, in a piece of paper, everybody has a notepad, and I'm not going to call on anybody, so don't worry about this. But if you can write the words literally, diversity, equity, and inclusion, and try to define them. Use buzzwords, whatever comes to your mind. And it's really going to help as we proceed. So those at home, please indulge me in that little exercise. All right, I saw some of you pausing as you wrote some words and then would pause to the next one and would pause to the next one. And I'm sure if you're using buzzwords and things that come to mind, you were thinking affirmative action or hiring more minorities, affinity programs. All big corporations love the affinity programs, and that for them checks the box. But when you were looking at your definitions and you were coming up with these definitions or buzzwords, did you observe any clear differences between the three terms? Did you see any overlap between the three terms? And the question that I would challenge all of you to think about is, can you explain the difference between the three terms? And the issue is that if we aren't clear on the definition of words and ideas, how can we ever come up with solutions? And more importantly to you, because I know most of you are in HR and I'm in employment. So in the terms of corporate respect, we're at the bottom of the totem pole, right? Employment attorneys and HR are generally derided by corporations. They think we get in the way of doing things. But this is why it's important about understanding these terms, because how are you going to make the business case for DEI? How are you going to explain the issues that you have with the corporation, or whether it's a market force or something that is driving your company's desire of this, really getting the DEI. And by the way, just the continuation of more acronyms in my life is very difficult. I have mild dyslexia, but anyway, if I say DIE, excuse me. So if we're not clear in the definition, how are we going to do this, right? So what I thought about, doing during this presentation, because this is what I did for that client that was asking me to explain to their executives, like, what is this? Is we actually go through the real technical academic definitions of these words, right? And the first one is diversity. Diversity is not race. A diverse candidate is not somebody who's Black or Latino. Diversity is the presence of a difference within a given setting. If you can, for example, have diversity of species in an ecosystem, or diversity of clothing brands in your closet, or diversity of opinion of experiences, that is the definition of diversity. It has nothing to do with race, national origin, or religion. And it is about a collective group and can only exist in relationship to others. And one of the biggest mistakes that I hear companies and people talk about is we need to hire more diverse candidates. Somebody is not diverse just because they're Black or Latino or Muslim or a woman. You can only be diverse in relationship to others. So for example, if you have an all Black wait staff, I have a lot of hospitality clients, you don't have a diverse team. I remember actually one of my colleagues in a prior firm, he was talking about his kickball league, and he said, my team is all gay males. And somebody commented, that must be the most diverse team in the league. And he's like, actually, it's the least diverse team on the league. Diversity is something that is in relation to other things. So it's something important for the company to keep in mind, that whenever, and I hear this whenever we have a Title VII case or something like that, a client tell me as a defense, is like, oh, we have a diverse company, Glianny. I have, I don't know, 40% of my workforce is African American. And I'm like, okay, so what do they do? And they happen to be in the manual labor, but the executives is all white. And I'm like, do you really think I can take that to court and try to explain that that's diverse? That it's not diverse, because you have mostly African American in manual labor and then executives white. So it is something to keep in mind. We need to change the way that we define diversity and think about it. Now, why do we have diversity? It is not required by law. Your business partners or your business clients, because you have your own internal clients, just like we have our external clients, think that this is required by law. And I hear that from clients all the time. I'm like, I'm supposed to be diversifying, diversification. And I'm like, no, that's not required by law. Now, the laws, like, discriminations still prohibit the use of a protected category in making employment decisions. But why? Why have people been talking about diversity for a long time? It is because diversity brings different perspectives that can improve the business. The most common example, or the best example I can give, and I learned this at it was a seminar conference actually for women of color. And they were talking about how women who have black skin have a hard time getting the faucets going in bathrooms. The technology to get the faucets going in bathrooms is based on light reflections. And it was created mostly by very pale white males in the Northwest. So they never took into account different colors of skin. So if you have darker skin, you actually might struggle more to get those faucets going. If they had had a diverse team in the development of that light technology, this would have not happened. So that's the value of diversity, and it's one of the most concrete examples I can think about. In terms of the hospitality, different methods of food preparation, presentation, and marketing, different ways through which you can reach a broader market. You need to have diverse members in the group to every once in a while say, oh, that campaign probably will be very insulting to my people. And it is something that people take for granted. In addition to categories protected by law, diversity of backgrounds and life experiences are important for perspective. And Black Latino grads from wealthy families may not necessarily have the experience or the skills to develop the techniques or the marketing, the sales techniques for families of color below the poverty line. My daughter is a privileged Latina woman. And so her life experience has been different than the average Latino immigrant to this country. So while she can provide a diverse thought of what it is to grow up a Latina woman in the South, being born in the South in Georgia, if you're looking for somebody to reach out necessarily to first generation immigrants, she might not be able to relate as well as some other folks. And that's why diversity is important, not just in terms of race, because again, if we think about diversity as a protected category, you're missing the point. It's about socioeconomic status. It's about regional diversity. You do want, even if you are a single site operation in Ohio, you may want to bring employees who are from other states if you want to have a national presence in many ways. So clients and business partners also are expecting diversity. You're starting to have more and more demand. Us lawyers, we do have corporations, and whenever we respond to proposals, we have to show, what our numbers look like. So that's another reason as to why diversity, but it is not required by law, and we need to learn to teach our business partners that. So how do we reach it, right? You cannot hire somebody as exclusion of others because of a protected category. That is still unlawful, and we do not see Title VII being reversed anytime soon. Laws against discrimination prohibit that. Now, it is okay for a company to identify groups that they just don't have enough, or they don't have that many African Americans or Latinos, and then target resources to get the pipeline of candidates there. So the ultimate decision cannot be, well, tell the recruiter we only want to see candidates that are Black or that are Latino or Muslim or whatever. However, you can start thinking, okay, how do we get this pipeline increase so we have more candidates that belong to protected categories, if that is your goal, or socioeconomic backgrounds. And that is you target sources. For some of my clients looking manual labor, I tell them, are you advertising in Latino-owned periodicals and newspapers and magazines? Are you going to the colleges and universities within Atlanta, such as HBCUs, but also technical colleges that might have a larger presence of a particular protected category of employees that you're seeking? So those are the things to be thinking about in terms of how do you get the pipeline. So it's okay, again, to say we do want to reflect more the population of our state of Ohio or Georgia or the Northeast or the Southwest or the United States. But what you cannot do it is we're only going to interview this type of candidate. But you can, however, increase the pipeline. And so that way you have more applications from candidates that are diverse as to each other and as to your workforce, and therefore you can consider that. So, one of the things that, when it comes about diversity is we can have all the diversity we want to, but do we have inclusion? And so let's talk a little bit about the definition of inclusion. And the best way I read somewhere online was diversity is being asked to the party, inclusion is being asked to dance. It's being together. Now, the technical definition that is used by many experts is inclusion is about folks with different identities, feelings, and feelings of being valued, leveraged, welcome within a given setting, right? They feel included. You can have a diverse team of talent, but that doesn't mean that everybody, particularly those who are marginalized identities, feel welcome or is given opportunities for career support or for advancement. Because we do have that issue again of at the lower level of the pyramid in corporate structures, you do have a lot of diversity between that group of people in terms of various races, religions, or whatever. But then once you start going up the ladder, you do not see that diversity reflected. So why do we care about inclusion? Well, the value that we talked about diversity, it doesn't really come or you do not get to take advantage of it if the employees are not feeling included. Because if the employee does not feel included, they're not going to be performing at their optimal level. And it's not selfish. All of us at some point in our careers have had that moment where we're like, well, we're not being heard. Nobody's paying attention to us. So why am I going to go the extra mile? My father-in-law always says there are the people who do more than what is asked of them, those who do what is asked of them, those who do less than what's asked of them. And sometimes you get a great employee who starts in a company and they're doing more than what is asked of them. But after a while, when they feel unheard or do not feel value, they start doing just what's asked of them. And then maybe at times they go below. We've all done that ourselves. We've seen going the extra mile, working the extra hours, and after a while, either we call it burnout or whatever you want to call it, the reason you stop working at that optimal level is because you do not feel valued. Employees will not share or contribute diverse background views because, again, if they do not feel included, then why are they going to come? And I'm like, you know what, we really should test that faucet on people of different color skins because that might not work. They will not seek to be promoted. Because if you do not feel included in a group, in a corporation, in an environment, why do you want to stay there? You're really not thinking about getting a promotion. They will sue. So that's when, we all come in, the lawyers. But more importantly, they leave. And one of the things that I do with business clients, and I help my HR contacts to make the business case for a lot of things. It is not about a CYA so we don't get sued or we have defenses. It's about developing our talent and keeping it, because that is significantly more costly than a lawsuit. Depending where you are, where you settling lawsuits for, anywhere between $15,000 and $35,000 a pop for even the bogus ones. If they leave, the value of getting the recruiter, paying the recruiter, training the employee, you're talking about a year's worth. You're talking more per employee, closer to $100,000. So that's a great way to make the business case for management as to why it is that we want this inclusive environment. Forget about the lawyers. Let's just think about retention. And right now, where we cannot find employees because they've just poof everywhere, it's something that is extremely valuable. So it's just one of those things to keep in mind. Questions to ask when it comes to inclusion. Now, when we're talking about diversity, there are two types of questions that we're generally asking about, right? Like, how can we get more diverse candidates? Why aren't people differing identities applying for our jobs? When we're talking about inclusion, the questions really need to focus a little bit different on what is the experience for individuals who are in the minority within the organization? What barriers stand in the way of people marginalized? And, they're getting identities feeling a sense of welcome, belonging. What don't we realize that is negatively impacting our our diverse teams? What's going on? And for me, the easiest, I need to stay close to, I like to walk around, so I know I need to stay close to the microphone. One of the easiest tests to gotta get the pulse of your corporation is when you have a team building exercise or you walk into the lunchroom, do you have people self-segregating? Do you have your Latino employees sitting with the Latino employees and the Muslim ones with the Muslim ones and the black ones with the black ones and the white ones with the white ones? That usually is a pretty good sign that something is amiss. And people, instead of sitting together based on the group of what they do or what their interests are, they're self-segregating. So that is one of the easiest ways to just kind of get a sense of how that works. So that's I call it the lunchroom test. Inclusion, how do we do inclusion, right? And this is where it gets very tricky because again, we're hearing about these DEI plans where executive compensation is being tied to targets. And then so the executive goes, hires the DEI person or DI person, you know, whether they drop the E or not, and they think problem solved. But the problem is you need management buy-in. So if they're going to get more money based on these things, they really have to contribute to their part. And it, again, it's making the business case for them to understand that, listen, if this is really going to be something that is going to be a cultural shift within an organization, it has to come from you as well. It cannot be something that we just have somebody else do. We have a DEI officer, we're paying her a lot of money, why can they do it? So the managers, the leaders, the executives need to get to know the team. They need to understand who they are, find common ground with them, create the common ground with them to the extent such does not exist. Team building exercises that appeal to a broader audience. You know, there's always the temptation. It's like, well, the golfing outing. Well, if you think traditionally of, you know, who golf attracts, first of all, by gender is an extreme percentage wise, like we know exactly how it is, but then you also get into race issues. So, or, you know, when it comes to whiskey, you know, you usually, if you're at the whiskey level, you probably come from a privileged background. So instead of a whiskey tasting or a wine tasting that make people feel uncomfortable, maybe a beer tasting, well, that may exclude the women. How about just food, barbecue competition, right? It's something that brings people together and it's less likely to be controversial in terms of who it excludes, much more so than who it includes. Events are unusual. And we were talking about axe throwing last night, but I had that in my presentation before we talked about it last night. She is apparently, yes. So we should all fear Nancy a little bit. So axe throwing, why am I suggesting something like that? Because it is so random and different that everybody's going to feel uncomfortable. So you do an event in which everybody's equal because nobody has done it. Pottery. I don't know why I threw at pottery. I was working the presentation late. Events to celebrate the diversity of the team, not just a potluck, but maybe Peruvian cuisine where the non-Peruvians have to cook the Peruvian cuisine because there's a coworker who's new, who's Peruvian. Or if you have a new coworker who's from the South, let's go have you know, a Southern barbecue and then have a debate about how grilling is not barbecue, by the way. And I've been in the South long enough where I can engage in this debate. Seriously, except with axe throwing Nancy over here. Proactively seek the involvement of participations of all. And here's the thing, when we're talking about the traditional business environment, what we always heard is, I want the person that comes to me, I want the proactive employee that reaches out to me. That's what you hear from business leaders. Not only are there issues in terms of there are some cultural differences where some people actually do not, you know, toot their own horn naturally because of their culture or where they come from, but also because people tend to do that and feel more comfortable with people who have things in common with them. So if your leaders are white, they have a white privileged background, the employees who have white privileged backgrounds may feel comfortable coming to them and asking them about, I don't know, the a cappella group that they sang in at Harvard or whiskey or one of those things. But the employees who do not have those things in common with those leaders will feel uncomfortable. So I grew up in very rural Puerto Rico and I went to undergrad there. So it was not law school that I went here. And then I started in big law. And I felt extremely uncomfortable when pretty much back then the firm at which I was, it was primarily white males, and I had nothing in common to it. And I can usually relate to an aunt, but I just could not find common ground with these people. So that's why it takes management and leadership and it takes some effort on their part to get to know their employees, to help facilitate finding that common ground. Eventually I did. I just kept talking people to death until I find out something I can share with them and talk to them. But not everybody is like me. Not everybody is going to be as proactive. So that's why it is important to get leadership involved, to get to know people, especially now that the compensation might be tied into that. And I'll talk a little bit about one of the things that that firm did for me and for other associates we thought was great. But you know, it kind of comes into the whole issue of equity and equality. I was shocked at a former colleague of mine who was a former GC at a major corporation once was shocked. We were talking about, I forgot how it came up, but he basically said, well, you know, you feminists want to be treated like men. I'm like, no. We want to have equal opportunity, not equal treatment. I still want to be treated as a woman. I still want, you know, my comfort level of my own culture to be respected. And he was just floored. And I'm like, this is not a new concept, Steve. And I'm not revealing who Steve is because there are a lot of Steves. It is why it's called the equal employment, you know, the equal opportunity in employment. It's been thrown around, and it's important to get people to understand that we're not, if we seek true equality in treatment, you have that first part of, you know, people just being with the same box. But when we're talking about equity, it's about recognizing these differences and doing something affirmatively about it. And the best example that I heard, and I'll talk in a second about, so that first firm, we could never figure out which, if it was one particular associate that did something wrong or many of us did something wrong, but they bought an etiquette teacher to give us a seminar. For me, it was a game changer. It really meant a lot. But one of the things she talked about was when you're interacting with international business people. And she said, explained that in Japan, for example, I want to make sure I keep you on time. It is important that men carry their business cards in their breast pocket and women can carry them in their purses, which we thought it was kind of curious. And they said, because everything in Japan has a symbolism behind it. So you take your business card, you're taking it out of your heart, you hold it by the two upper corners and you provide it to the person. And then the person who receives it is supposed to read it and equally save it in a pocket like that. And she said, the worst thing you can do is pull it out of your butt and go ahead and give it to, like, the symbolism behind that is awful. The other example that she gave is in Brazil. You do not drink out of bottles or cans. And apparently there was a big executive meeting at some point between an American company and a Brazilian company in Brazil. And the American executives were drinking out of the bottle. And at some point, the CEO of the Brazilian corporation could not take it. He stood up, grabbed a glass, grabbed the bottle and served it and said, we're not animals around here. We do not drink out of vessels in which the food or containers. And the reason I bring this up is because going back to how we like to be treated, and when I told my colleague, I still want to be treated for who I am, is this concept of do unto others as you would like to do unto you. I challenge you to think about it, do unto others as how others would like to do unto themselves, the way they would like to be treated. And that means taking into account cultural differences. So if whenever we're going to interact with somebody from Italy or some other area of your corporation, if it's international or maybe a potential business partner is coming over, you learn about their culture and you learn how to treat them. And whether you shake the hand or whether you bow or whether you take your business card out of your breast pocket as opposed to your butt pocket, it is important to actually get to know that within our own workplace, with our own coworkers. We have some people who are more touchy-feely. And if I am a person that happens to like my personal space, then you should respect that and not say, well, you just all have to get used to it. So that's what we're talking about sometimes in terms of how we treat each other. But going back to equality and equity, it is important that we think about also the definition. Again, if we do not understand the terms and how they're being used, it's very hard to come up with a solution. So equity is an approach that ensures everybody has access to the same opportunities. Equity recognizes that advantages and barriers or disadvantages exist, and that we don't all start from the same place or have the same background. It's not, you know, the word privilege was used a lot because it is shocking and it calls attention to an issue. So from a marketing standpoint, it is extremely effective. But then now it has gotten diluted into a lot of people saying, well, my background was not privilege. I was somebody with low socioeconomic background from South Georgia or anywhere else around here. So that kind of got lost in the mix. So it's just recognizing those differences that might prevent somebody from excelling at work. Equity is a process that begins by acknowledging that unequal starting place and makes a commitment to correct and address the imbalance. So going back to that etiquette class, for me, what was life-changing is nobody ever taught me how to use the forks or the spoons at a table. And when I had gone to a couple of banquets in law school, I felt extremely uncomfortable. And nobody taught me even the DD of bread, or which I still do under the table once in a while, by the way. I have dyslexia, so I have to. But nobody had taught me that. And it was invaluable, the fact that I was empowered now to feel comfortable at a dinner table. That was you can call it an equity or disadvantage or barrier for me feeling comfortable in a lot of settings with clients that now had been taken away. She taught us how to hold a glass of wine. She taught us that whenever you're dressing for a business meeting, you don't want more than, I think she said 7 shiny things or things that call attention. So for men, watches, belts, shoes with tassels, maybe the buttons of their jacket. For women, jewelry was included. And it's just these little things that just resonated with me and facilitated my ability to get dressed in the morning and feel comfortable whenever I was meeting with a client. So those are the things that we're talking about. It's not taking away from somebody and giving it to somebody else necessarily. It's more about recognizing those differences. So in the how, I just talked about that. It's this help with this difference. Classes on etiquette. It really was, to the extent you have a labor force and you have some, a young workforce that might come from first, generation immigrants or something like that who are not used to that. It can be extremely helpful. Classes on whiskey. I'm sorry, but if the clients that these people are interacting with are going to have to, they're going to want a whiskey tasting. You may have to just pay for classes for your own workforce to feel comfortable with these things, with golf or with grammar. I did have that first law firm help me with getting some legal research and writing seminar, not research, but writing seminars. It is important to help them succeed. And then people always say, well, that's not fair. Why are we having to make up for society's failures to educate them properly or for their families' shortcomings? You do it already. You just primarily do it for the people who are in control. There's a lot of talent in a lot of corporations that people say, like, he's a great leader, but he has a little bit of an edge. We need to calm him down. Let's send him to a class that is a management class. He needs to learn how to control his temper. So we're doing it for the white dude. Why can't we pay for the golf class or the whiskey glass for the other member? So that's how you do the business case for the corporations. Like, we're already doing it for some people. So what we're identifying is we have somebody who's talented, but there's this little thing about them, and we can correct it. And in fact, probably a whiskey class is going to be less than a class on leadership or management or anger management, software programs. It is no different, because sometimes you have somebody who has a raw talent but may lack the interpersonal skills. Sometimes you have somebody who has fantastic emotional intelligence and interpersonal skills, but lacks behind some with respect to some other skills or technical things. So you send them to those classes, and that's all we're talking about. That's how you achieve equity and bring everybody together. And have a mentor, supervisor, leader go the extra mile and talk to people individually about cultural differences, how to shake a hand, posture, saying good morning, eye contact. A friend of mine contacted me. He's in the engineering world, and he said, we have this great candidate, bachelor's degree, master's degree from a highly regarded technical school. He came to the interview. He is exactly what we need, and we're having difficulties in terms of hiring anybody else, but we have an open floor plan, and he smelled. And everybody else who interviewed had said that he smelled, and we noticed his shirt was old, but he's not from this country. And if we say something, we're going to sound like we're racist pigs. So there's nothing we can do. We're going to miss out on this candidate. I'm like, whoa. You cannot blame an entire country for somebody not having certain ability, certain knowledge as to what's common or not common, right? But he has the skills. I'm like, no, it's not racist or discriminatory to say something about it. And what I suggest you do, honestly, is ask the company to give you a $500 budget, take him shopping, because there was an issue with the clothing. He had been in the US for a very long time, studying, living off of scholarships. He didn't have that much money. And you need to bring up the hygiene thing. And he was hired. He was an amazing engineer. But that was the kind of thing that is like, it was a small barrier It didn't take much. It can be done and it's not wrong. So again, if we do it for some folks in terms of, okay, let's go ahead and pay them for classes for them to get the MBA, why not do it for others if they can be equally talented? So that's the kind of thing that you can do, and that can be done on an individual program or individual basis. Does not have to be, a group basis. Take someone shopping, one-on-one lunch, to a sushi bar. Somebody did take me to a sushi bar and taught me how to use chopsticks. That was very exciting for me. By the way, I have turned into a complete foodie, and now there's no stopping me. I will eat anything in front of me. So why do we have, the case for equity? Why do we want equity? When, the big reveal is that when an employer takes proactive steps to create equity or eliminate inequities, employees from different backgrounds feel included. And the employer will then and only then reap the benefits of diversity in a diverse workforce. So that's why the E is being added to the whole DI thing. That's where the equity comes into place. It's not enough to have employees from different backgrounds and different protected categories. It's not enough to have affinity groups and throw them parties. It's about how do we correct any differences in there and make sure that they succeed? How do we proactively take steps to make sure that they can do well? And so this is the part that I talked about in terms of a case being published right around the time that I was working on the presentation. $10 million was a judgment awarded against a North Carolina healthcare system because of discrimination. It was because of DEI plan. Basically, that was the main evidence that they used at trial. They showed, and there were a couple of things in the plan that I wanted to read to you. That they consider the jury and found invaluable. Us lawyers, after we're done with the trial, we tend to go ahead and talk to the jurors and interview them about what was persuasive or not. So in this case, what happened is they had the DEI plan that specifically said, we are going to use a diversity lens in our decision making. And by diversity, they meant hiring people from protected categories under Title VII and the ADA and ADA, whatever. So you already have in writing what you're not supposed to do under the law, and that is take somebody's protected status to make an employment decision. The second thing is the senior leadership who would have a long-term incentive plan based on targets of hires, of how many African Americans they would hire, how many Latinos they would hire. So this gentleman, typical case, had always had outstanding reviews. He had been with the company for many, many years. He was one of 5 white males in the executive management level that were terminated around the same time. And because of this DEI plan and the way that there was a focus and an emphasis on these things, he was able to prevail on his claims for discrimination. He was replaced, by the way, his position by 2 employees. So he did enough that he wasn't replaced by 1 person. He was replaced by 2. They were both women, 1 Black, 1 Latino. And we are expecting these cases to start coming down. So the danger of a DEI plan being out there in corporations for the sake of being there and being just more of an afterthought or something that you want to put on your website or whatever, it's going to seriously result in some harsh judgments and legal risks. Importantly, we are expecting the judge to reduce the amount of liability, but because it was a highly paid executive, it's not going to be reduced by much. It's not going to be capped at $300,000. We're not talking about compensatory damages. This gentleman made serious money, and therefore back wages, front wages is going to be significant. Recently, a coworker of ours in Atlanta was talking about a case that he had where there was a company in aerospace. And so what they said is we want to have more people of color and women. And the person who sued was actually a person who was of color, but they were over 40. And the theory went that by focusing, how under the ADEA, generally speaking, you can have a neutral looking policy that doesn't really have to be an age if in effect it has an effect of discriminating against people from a certain 40 or older, then you can be held liable. So that's exactly what happened here. And this was very interesting, and I have to give credit to the plaintiff's attorney for thinking about it, and maybe it's just one of those things that we never really thought about. There's just not that many engineers who are women or people of color in the old age and in the older generation. So if you're going to hire primarily women who are aerospace engineers or people of color, you're really looking at Gen Xer or millennials. because to the extent they were kids that were interested in aerospace engineering, they were probably, given a lot of obstacles and barriers for them to study those degrees. They didn't see a future in them. So by focusing on hiring women and people of color in aerospace engineering, they were by default pretty much rejecting anybody who was 40 or older, because that group, that population was mostly white males. So I thought that was a very interesting observation. And that is something that, when you're developing these plans or these hiring targets, cannot be done in a vacuum, because you have to understand that if there are not that many candidates from a certain generation that are going to be in a particular group, then you might be discriminating. So what are some of the things to do? If you have the DEI plan, you want it in writing. And the reason you want it in writing is because you want one source, just like a policy. We want everybody to be working off of the same book. So that way there's some consistency across. But what is important about that too is it has to be vetted by legal and HR. Let's make sure that the EEI officer that your company hired is not working in a vacuum and is not going through you, because you need to reconcile those DEI policies with your own HR handbook and with your policies, and how it is that you hire internally, how it is that you do internal job postings, how it is that we're doing. So it is very important to do that. It has to be tied into the anti-discrimination and harassment policies. Don't let it focus on categories protected by law. Make sure that people understand that we're talking about diversities, that definition of things that are different to each other. It is not blacks, it is not whites, it is not Latinos, it is not Muslims, it is not African Americans, it is not LGBTQ, we're talking about really people from all sorts of different backgrounds, and those include some of those protected categories. But all diversity is good. Very careful with those targets. When it appears that you're making a decision not, based on a protected category, you're going to get in legal trouble, and you're basically putting in writing the case for the plaintiff's attorney. So that has to be extremely well thought out. And again, you can think about increasing the pipeline, who it is that you want applying for the jobs, how do you develop your internal candidates, all candidates. You're going to give everybody a fair shot at being promoted without excluding others. It's very important to keep that. The recruitment should focus on candidates pipelines, not reference protected categories. And one of the things also when it comes to socioeconomic background is the issue that it's not necessarily what the kid looks like, but in a lot of struggling families, you don't get the opportunity to go to a university far away. So we're not talking only about HBCUs. Sometimes you have to get out of the urban areas where there are a lot of universities and colleges and go to those technical universities or smaller universities. Surprisingly, I was actually a pretty smart kid in high school, but I had to go to the local university near me because my family could not afford to pay for dorms somewhere else, and they were also not going to let me culturally. The idea of the daughter to go by herself. So I lived at home when I was in college, and that is not just my reality. When my daughter was going off to college, my husband and I were happy to kick her off the nest. We were ready for that. But I'm talking to other Latino professionals in Atlanta with whom I'm friends, and they think I'm crazy. They're like, wait, she got into Emory, and you like, she could have lived at home. You could have protected her from boys. And I am just shocked about, this reaction within, I always thought, so this is a socioeconomic thing, right? It was my family, we were poor, they had all these concerns, but I am finding a lot of cultural differences in terms of how higher education is viewed. So sometimes you have to recruit outside of your area, not expect candidates to come to you when it comes to socioeconomic status. Also, some kids, it could be that, I'm almost done. It could be that the family struggle, or the mom had cancer, or the kid is working part-time and going to the local university. So that's why it's important to think about socioeconomic status and open the pipeline of the schools from which you recruit. And train the executives and leaders on how to implement the plan. It is important they have the buy-in, and if you want the money, dude, you have to put in the work. So if there's going to be an incentive, long-term incentive plan or bonus or anything like that in some sort of target, which is a horrible word in my world, it is important that they understand that they need to walk the walk, not just talk the talk. And include all, even employees from whichever group they're in the majority in the company or department, and make sure everybody feels welcome. So if you do have a department, let's say they're all Latinos and there's 2 white women in it, you have to address to the extent that they're self-segregating or there's any inclusion issues to make sure that they feel comfortable as well. That's my contact, that's my CLE information, and I am over by 2 minutes.
You're good.
All right.
We're forgiving. forgiving, plus or minus. Thank you.
Does anybody have any questions? I know it's a sensitive subject, so I don't expect too many questions, but I'll stay around lunchtime, so please feel free to reach out.
Awesome. Thank you so much, Glianny. For those of you who may just be on the phone and maybe not seeing the slides, the CLE for the third segment, if you're on the webinar, TH1116C as in cat. TH1116C as in cat. Now I'm going to introduce my partner, Debbie Brenneman, who is a partner in our Dayton and Cincinnati offices. She is our extraordinarily gifted partner who deals with non-compete and trade secret issues in addition to an array of employment issues, but she's really the go-to on these issues, so I'll turn it over to her.
Thanks, Nancy. Thank you. Although I'm not sure what I did to make you angry, because not only do I have to follow Glianny, but I'm the only thing standing in between these guys and lunch. So thanks a lot. So I guess what I'm going to have to do is just scare you guys, to scare the crap out of you. So show of hands, how many of your companies use some form of non-competes or non-solicitations? A good chunk of you, and I'm going to assume those of you who are remote, I'm going to assume all of your hands are in the air. Well, it's a very important time. I've been going around the country enforcing and defending non-competes and trade secret issues for 20 years or so now, all over the country, and I can tell you the landscape is changing, and you're probably all aware of it. It's changing with regard to non-competes, and this little thing called COVID has changed trade secret issues as well, which we'll talk about a little bit later. So there are really some important things to keep in mind, and if you haven't, I'll talk about this again at the end of the trade secret section or non-compete section. But if you haven't looked at your non-competes for a while, if you haven't updated them for a while, if you haven't analyzed them for a while, believe me, the time to do it is now, or call us and we'll help you do it. What we're seeing, I mean, everybody knows that non-competes are a no-go in California, right? Absolutely can't enforce them. Even if you get an order from another state, California is not going to enforce it. Sometimes I think if you stand on a street corner in California and say the word non-compete, you're going to spontaneously combust. But in any event, non-competes are off the table in California. But what we've been seeing is that trend against non-competes has really been cropping up over and over and over again in states and even in some municipalities, especially the large cities. And we're really seeing some concerning developments if you're an employer expecting that you're going to hold employees to the benefit of that bargain. You've paid them a lot of money, you've trained them, you've put them in contact with your customers. You want to make sure you protect that goodwill when they leave, and you're now being limited in your ability to do that. So there are some states that are now prohibiting or nearly prohibiting all non-competes. Again, California, that's a given. North Dakota, that's pretty much a ditto. And there's a statute in Oklahoma now that says that an employee shall be permitted to engage in the same business as that conducted by the former employer or a similar business, as long as they're not going after directly soliciting the customers or the combination of goods and services from the established customer of the former employer. So really in Oklahoma, you're looking more like a non-solicit anymore instead of a non-compete. So very narrow parameters. I don't know if any of you saw what happened in the last few months with regard to DC, but this really tops the cake, I think, because now DC is saying not only can you not have a non-compete that restricts your employees' abilities after they leave you, by the way, you can't tell them they can't work for a competitor while you're paying them, while they work for you. So no non-competes that restrict their ability to compete against you anywhere, anytime. That's if you have a DC employee or if you're a DC employer. So if you're a multi-state operator and you have employees that work in DC, this is your reality. And by the way, if you have employees now who decide that they're going to remote work and they might be remote working from DC, you better pay attention to this because this might apply to you. It also requires employers to provide notice of the new law on an employment poster. So in your posters, this has to be listed. Gives employees a private right of action if you violate this. So if you violate it in your policies, they can sue you for that. And it allows the mayor to impose some financial penalties on you as an employer as well. So very sweeping legislation in the District of Columbia. Some other recent legislation, well, in Oregon, there's some pretty restrictive measures with regard to non-competes. It had been an 18-month maximum on non-competes, and that's been reduced back to a 12-month maximum. The employer has to provide written notice of the non-compete at least 2 weeks before the start of employment. So if you make an offer, you got to give notice that you want them to sign a non-compete 2 weeks in advance. If you're going to give it in connection with the promotion, you have to give that notice then. It has to be a non-exempt or an exempt employee. It has to be limited to protectable interests, really looking like things like trade secrets, confidential relationships, et cetera. And here's the kicker. It's now limited to employees who earn more than $100,533. And I really want to ask the legislature, like $533, really? Can't we just go $100,000? But anyway, that's the law. It is limited to employees who earn more than $100,533. And during that restricted period, you have to pay them during that time. So it's looking a lot like what a lot of European countries do. So that's a new law in Oregon. In Nevada, prohibitions against non-competes for hourly employees, and it limits the ability to restrict a former employee from providing services to employers, customers, or clients. So kind of like what we saw before, if it's targeted toward limiting them, restricting them from touching your customers, really playing the same game they played for you, that's okay. But going beyond that is going to be difficult. Other recent legislation that we've seen, a lot of these states are seeing some salary caps on these sorts of things. In Illinois, $75,000 salary threshold for non-competes. For non-solicitations, it's a $45,000 salary threshold. And there are built into that automatic increases in that threshold. So every year for a couple of years, that number increases, and then there are continued bumps for every 5 years, I believe, into 2037. So very long-term extended bumps on that. So again, your non-compete should not just sit in a drawer somewhere. You need to take them out on a regular basis and see how they compare with what your restrictions are. In Maryland, we saw recently another salary threshold cap. This is a pretty low one compared to what we have been seeing. Virginia now prohibits non-competes for low-wage employees, and the Virginia legislation defines low-wage employees as those whose average weekly earnings are less than the average weekly wage of Virginia. Low-wage employees also includes interns, students, apprentices, or trainees employed with or without pay at a trade or occupation to gain work or educational experiences. They also include independent contractors, and again, they have to be compensated more than the median rate of pay in Virginia. So lots and lots of legislation that's on the rise. We're continuing to see a trend toward more legislation, so that will be increasing. What we're also seeing is sort of an increased debate on choice of law provisions. So I have a lot of clients who they're based here in Ohio, where a non-compete law is pretty favorable, or you see a Delaware choice of law provision, or a choice of law provision where the company is located and it's pretty good law. But you might have employees in a bunch of different states, right? And so what do? Well, I advise most clients to try to stick with the law where you're located if it's good law, right? Unless the law is going to be different in the states where, materially different in the states where the employees are located, such that they don't enforce these provisions. And we've seen some case law that is addressing these issues, and it's going both ways. We did see a First Circuit court take up this issue and enforce a Delaware choice of law provision in an evasive non-compete matter. But the same month, the Third Circuit ignored a choice of law provision and said it violated public policy of the state of Nebraska and refused to enforce that choice of law. So what to do? Certainly be thoughtful about that. Again, look at your non-compete provisions, and you may have to, even though you have a choice of law provision, consider that it may not be enforced. So what do you have to do within the contents of your non-compete to make sure you're complying with the Oregons or the DCs or the Nevadas of the world, so that if that state's law takes precedent, that you're complying with that and you're able to enforce your agreement as well. The other thing that we're looking at is the possibility that there may be some federal legislation on the horizon. So President Biden signed a few months ago an executive order encouraging the Federal Trade Commission to consider regulations that wouldn't curtain, non-compete agreements, but would curtail the use of non-compete agreements or other clauses or agreements that may unfairly limit worker mobility. Now, this encouragement order was issued a few months ago. We haven't really seen anything about it yet. We're all staying very closely in tune with that. So there are a lot of questions here. Will the FTC act at all? This isn't a directive, it's encouragement, may take it up, may not. And what exactly will this look like? You know, the popular thought is that it probably would not eliminate non-competes altogether, but it might significantly restrict them. Will we see federal legislation that looks like that salary threshold cap? Will we see it limited to certain occupations? Will we see it tied to just certain interests that you're protecting? So it remains to be seen. One thing that we're very interested in is would it also address non-solicitation provisions? Most of the legislation that we've seen, not all, but most of the legislation addresses non-competes and not non-solicitation agreements. So if the feds take action, will that include non-solicits as well, or just non-compete agreements? And what exactly would the enforcement mechanism be? All questions that remain to be seen. We did see a bit of a preview of where the FTC's thoughts may be lying in this. They hosted a workshop in 2020 on possible rulemaking to limit the use of non-compete agreements. And they invited comments on a variety of topics like what impact do non-competes have on the labor market? Does it prevent mobility? You know, what is the impact to employees? What are the business justifications? Why do employers need them? Why are they necessary? Is state law enough? Do we need to step in as a Fed, or does state law sufficiently cover this? Are there situations in which a non-compete clause constitutes an unfair method of competition or an unfair or deceptive act or practice? So these are the kinds of things that the FTC was looking at when it was inviting comment. And again, we're anxiously waiting to see if anything occurs. This certainly was something that President Biden was part of his platform. It's something that's been bantered about in Congress a couple of times over the last few years and didn't really get any traction until now. So another thing to stay tuned on. So what do you do right now as an employer with all these things on the horizon? Well, again, if you have not looked at your non-competes or updated them for a while, do it, do it, do it. Do it on a regular basis. Take a look at where your employees are, see what the requirements are in those states or those localities. Make sure you are factoring those in and be compliant with it. What we're seeing with these legislations is that they're really looking at, do you need it as an employer? So if you are having your low-level employees sign non-competes, maybe you shouldn't be doing that. You know, that's where we're seeing a lot of blowback. And even in states where there aren't laws prohibiting it, you're always going to face a court that's asking, you know, is this equitable? Should we enforce this non-compete against this individual? And when you're talking about enforcing it against a very entry-level person who maybe is paid $30,000 or $40,000 a year, who doesn't have a lot of customer contact, is a court going to say, yeah, we should stop them from working? You know, maybe, but maybe not. So maybe you're going to spend a lot of money trying to enforce something that is not really going to stand up. Your non-compete should not be a one-size-fits-all type of situation. You should be looking at having standalone non-solicitation provision agreements, perhaps, for folks who don't really need to be bound against going to work for a competing company, but maybe you really just need to protect your customer relationships, right? You want to have a couple of different levels of agreements depending upon the level of your employees. A base level non-compete for managers, a different type of non-compete that maybe is based upon the type of services they perform for more technical members of your organizations, and the broadest level of non-competes for your top executives, your C-suite folks who really do steer your company and have, you know, perhaps nationwide or international authority within their scope of operations. So you really need to take a look at those. It's going to help you as these laws evolve. It's going to help you in an enforcement situation. So you want to make sure that you are doing that now. Now, of course, non-competes go hand in hand most times with protecting your trade secrets, right? It's very rare that I am working on a non-compete case that does not also have a trade secret component to it. So the bad news is that has also changed in the wake of COVID in terms of the protection of your trade secrets. So in terms of protecting your trade secrets, you have to first define what it is that is your trade secret, right? You have to be able to demonstrate that you've invested a lot of time, a lot of money into developing this trade secret, that it gives you an advantage in the marketplace, that if your competitors have it, it would give them an unfair economic advantage. And also that you're taking reasonable steps under the circumstances to protect the integrity of that trade secret information. So the new question is, what's reasonable in the new world we live in with COVID? And this all sort of came crashing upon us in a case about a year ago called Smash Franchise Partners versus Canda Holdings. And this was a case out of Delaware, and it was a case in which Smash, which was literally a company, a franchise company that compacts trash, and it was seeking different franchisees for its operations. And a couple of folks who had sought to be or signed up and said they were interested in being franchisees took a lot of information, and then they promptly went out and started their own competing company against them instead of signing on as a franchisee. And Smash then went to court and tried to seek an injunction to say, hey, they gained all this information. They're using our trade secret information to start up this company. We provided them all of this data, and now they're using it against us. Well, the court denied their request for injunctive relief, and they denied it in part because of what happened on some Zoom calls. The new reality for all of us, right? All of our WebEx calls and Zoom calls and Microsoft meeting calls. Well, this was part of the downfall of this company's attempt to get injunctive relief. So the court found that during these Zoom calls that had been set up, the franchisor shared a lot of trade secret information with these potential franchisees. It shared confidential information, shared information about how, its best practices, how to, run this company. And the problem was that during this Zoom call, it was pretty loosey-goosey with the Zoom call. So the information on the franchise forum calls was freely provided to anybody who said, hey, I'm interested, I'd like to participate in this call, if they had just completed an introductory call. The plaintiff didn't follow the Zoom security procedures, and it didn't follow its own security procedures. So it didn't require that participant password. It didn't use the waiting room that's provided, didn't even use its own procedures to do a roll call at the beginning or to remove anybody that didn't belong on that Zoom call. So the court found that, you didn't take reasonable steps to protect the integrity of your trade secret information. And that really, again, is a very stark wake-up call, because the reality now is we're doing a lot of different things a lot of different ways, and your trade secrets may be put at peril because of that. The lesson of this particular case was, with regard to these platforms, make sure you are learning the security information that security measures provided to you, make sure you're using those security measures, and make sure everybody who is participating in them is trained on those security measures. So don't just give them the setup, this is how you do your Zoom call, here's your access. Make sure they know what security measures you need to put in place when you're doing these Zoom calls. But it really does show that there's a grave danger, and the fact of the matter is, not only did we all work remotely during COVID, right, but we're all learning that remote work is going to be a lot more of our ongoing reality than we 2 years ago ever would have thought that it would be, right? Lots of us are still working remotely part of the time. You see these statistics about the number of people who want to continue to work at home. A lot of companies are dealing with this as a retention issue. People now want to work at home. It's hard to recruit people to come into the office full time. And we'll talk a little bit more at lunchtime about this new workplace and what it looks like. But there are lots of different dangers that are inherent in working remotely. And again, working remotely may not just be that your employees are working from their home office with the door shut and they're in there by themselves. Working remotely might be they're at the beach, they're at Starbucks, they are at their neighbor's house, they are their spouse or their partner or their roommate is sitting across the kitchen table with them while they're doing their work. There may be other things, other calls going on. They may be engaging in use of social media while they're doing their remote work. So you've got increased risk, and you need to think through how that impacts. Are you taking reasonable steps to protect the secrecy of your information? You've got increased hacking risks. working from home. You don't have the same security measures that your IT crew sets up in a traditional office environment. Your employees are handling trade secret documents and information not in your office. So when they're pulling up things on the screen, who is around? Are they in Starbucks? Can someone look over their shoulder? Is their roommate sitting right there? What are they doing if they print out documents? What are they doing with them? Are they just throwing them in their trash can? Are they throwing them in the Starbucks trash can? Are they shredding them? Are they bringing them back into the office? Are they leaving them in places that could put you at risk for somebody saying you're not protecting the integrity of your trade secret information? Are they leaving them lying around by mistake? We're seeing an increased use or an intermingling of personal devices. So somebody has their work issued laptop, they might have their personal device at home, a tablet that they're using, maybe they use, again, their spouse's computer. Is your information being commingled with other sources, and how are they storing and accessing that information? Certainly, you have less visibility over their communications with third parties. So when they're talking to their contacts, are they limiting what they're sharing with those contacts, within the parameters that they should be, or do they feel more free to share? Oh, you should see this new product we have coming down the pipeline. I shouldn't tell you about it, but this is what we have coming up, and here are the features, when they maybe shouldn't be sharing that yet. And if they were sitting in a cube at the office, probably they wouldn't be doing that, but they might feel more liberty to have that conversation when they're not in those confines. And you have increased risk of phishing and spam types of issues in a home environment, and particularly with personal devices. So what do you do? Well, first of all, you do at a base level all the things that you've been doing before. That's your starting point, and then we're gonna have to add on from there. So those things are: identify your trade secrets. Make sure you as a company know what your trade secrets are. Make sure your employees know what your trade secrets are. When you have those agreements, confidentiality agreements or the non-solicitation agreements, take that time to think through what things are you protecting? Your strategies. Is it formulas? Is it your customer contact information? Make sure you're aware, train your employees that they know what that information is. Take the time to make sure documents, if they're hard copy, when they're printed out, they have a confidential stamp on them. When they're viewed electronically, they have that confidential stamp on them, so that it's seen. It's a reminder to employees that, hey, I need to treat this differently. Make sure electronically that you are using passwords, and ever more complicated passwords. I hate the passwords we have to use now. It's like 87 characters you have to type in, and then I create the silliest of sentences so I don't forget it. But enhance those passwords, and make sure that you're using firewalls. Consider encryption. Make sure you're limiting access, of course, to those with need to know. And that's things that you should have been doing anyway. But what now do you need to do in addition to that? Those things plus more. You need to be addressing, if you have remote employees, address the security measures that they have at home. If you're permitting them to work from home as an employer, you're permitted to tell them what security measures they should have in place to make sure your information is not compromised. You should have it in a policy. You should tell them about it. You should provide them notification about what they need to do. So make sure you're setting the minimums that you think are required for home security standards for your employees. Make sure they have Wi-Fi passwords. Consider multi-factor authentication to log into a company portal. Just make things a little bit more difficult, a little higher level to get into your systems and have access to that information. Set the standard again for things like antivirus software. Make sure you're thinking about that, communicating that with employees. And certainly up the ante on need to know. Go through again, who has access to what information? Should all of those people have access to that information? Maybe should they only have access to certain types of information in the office as opposed to being able to access it remotely? You can structure things in a number of different ways. There are, beyond your own IT departments, there are vendors who can help structure and provide the technical information on how to create this increased security for you. And think about your policy. I strongly encourage that you prohibit downloading of your information to non-company devices, or at least have very stringent policies in place about your ability to review those devices, wipe those devices, inspect those devices. You should not be, your policy should really think through whether that should be permitted and who should be able to do that. And impose restrictions on the use of portable devices. Again, this should always have been done, but particularly important now that you should be prohibiting the use or restricting to the use of those devices, consider blocking ports, and define your personal device policies. Again, things like phones that people have, laptops, require those baseline security and virus protection, require updates, utilize remote wiping software. So make sure your employees know and invest in that technology that you can wipe your information from these devices and that it's permissible for you to do so. Make sure your policies say that they are prohibited from transferring your trade secret information to portable devices unless under some very stringent standards. You should also consider monitoring policies. These are, again, something that I've always recommended in certain circumstances for employers, but even more important in this remote workplace. And those policies can come into play in a number of different types of scenarios. One is routine monitoring. Just have it set up so that periodically everyone's use of data and information is monitored, that people, IT just jumps in and inspects what documents have they been looking at, what things have been accessed, what things have been downloaded, that this is just a periodic review. Not all companies do it. It's certainly best practices to have that kind of thing done. You can also use suspicious use monitoring. There are methodologies for putting into place systems that alert you if someone accesses a large number of documents in a short period of time. If they access documents that they wouldn't ordinarily access in the course of their ordinary duties. Or key data monitoring, that you have certain key documents, strategic documents, formulas, high level, very sensitive documents that anytime they're touched electronically, someone's going to know about it. And you can say, is this a valid use or should we look into this? So again, particularly in the light of remote working, things that you should keep in mind as part of your arsenal, part of what you can do to protect your trade secret information. And renewed training. We all do annual EEO training. Where I think employers sometimes stumble a bit is providing training on protecting your information. The best time to protect your trade secret information is before it walks out the door with your key employees, right? Best time to do that is while they're still there and you can do something about it. And it starts with training and making sure that folks understand what your information is, what your policies are, how you expect them to handle your documents and information. Reminding them about those remote services and how they should be treating those, and training them on those security measures, how to realize when something is a phishing or scam operation and how to report that. Also consider how you're handling departing employees or employees that you may still be putting on layoff during times as things go up and down. Certainly for key employees who had access to sensitive business information. Number one, make sure that exit interviews are conducted. As people are working remotely, it's more difficult to make sure you're conducting those exit interviews. Even if the exit interview is remote, conduct it. Ask them, what other devices have you been using? Have you returned all information? Have you returned all credit cards, all your storage devices? What storage devices have you used with a company computer? What storage devices have you used with any other computer? Now look, they may not always be honest with you. And if they're going to work for a competitor and they're not telling you they're going to work for a competitor, they probably are not going to be honest with you about that. But you have one set of documentation where they've made an assertion to you about what they have or have not done. If you have to go to an enforcement action because you later find that they've done something awry, then you have that evidence that they can't be trusted. They look like a bad actor. And those are always the kinds of things that help tip the scale in non-compete and trade secret cases where they look like they can't be trusted. The judges don't like that. And these are the kinds of facts that you can gather and at least say, hey, and also we're reminding them, give us the stuff back. If they are remote, make sure you are sending them a FedEx box to get that equipment back to you the next day, or send someone to get it, or provide a drop-off. You don't want a lag time where they've resigned or you've terminated them and they've got their computer at home for another 2 weeks. Certainly turn off their access, but get their stuff back too. With key employees, I always recommend, or suspicious employees, if you think somebody is going to work for a competitor and they're saying, I'm just going to take some time off, travel, figure out what I want to do next, and you think that's probably not what they're going to do, or you've got high-level employees, I always consider, again, do you want to take the step to take a look at what they've done on their computer? What have they been doing in the last 30, 60, 90 days? Have they been using portable electronic storage devices? Have they been accessing documents? You can do that, or you can simply put the computer on a shelf until you see if there's a need to use it, or at the very least, make an image, a forensic image, a mirror image of the hard drive of that computer before you put it back into circulation. Maybe you don't need to make the investment right away to take a look and see what they've done, but if you find out 3 months from now that they're now doing the same job at your fiercest competitor, then believe you me, you want to get that mirror image off the shelf and have somebody take a look at it and see what was done before they went there. For your departing and furloughed employees, automatically, immediately remove their network access. Make sure that you have a good rapport with IT, where as soon as somebody is out the door, they know that that access has to be cut off. And if you have folks that are going on layoff, a good idea to cut off that access when you have them on layoff or furlough. Make sure they understand they shouldn't be doing work. Make sure if they're laid off, if they have devices at home, again, send those back in. Return company information. That can be reissued to them if they're brought back in, but you don't want those things laying around in their hands when their future with you is uncertain and they may be out there taking a look at what their next opportunity is. So get your stuff back in the event of a layoff as well. Talking about a couple of other trade secret issues in the time we have remaining, which I want to take a look. 5 years ago now, seems like just yesterday for weirdo geeks like me who love trade secrets, but it was 5 years ago that the Defend Trade Secrets Act was passed. And this was an important piece of legislation for, in terms of the attorneys like me who enforce these kinds of actions. It gave us an immediate access to federal court, right? If you have a trade secret issue, you can go right to federal court, whether there's diversity jurisdiction or any other kind of jurisdiction, because you've got the statute that says you can do that. And that provides you with a key strategic advantage in a lot of cases where you might be have a state court jurisdiction where judges aren't as familiar with non-competes or trade secret issues, don't like to enforce those kinds of issues. If you've got a trade secret claim, you can zoom right into federal court. Don't know that that was necessarily the goal of the legislature when they enacted this, but it's been a big advantage in terms of litigating these kinds of cases. But there were really 3 key goals of the statute at the time that it was passed. One was to create this federal civil remedy and to bring the rights of trade secret owners into alignment with those enjoyed by owners of intellectual property. Second goal was to promote uniformity. So instead of having this patchwork of how states applied trade secret principles, to have more of a uniform federal law that would develop, and also to better address the global concerns with the international business community and being able to address those concerns. How are we doing 5 years later? Well, certainly lawyers like me have taken advantage of the act, because we saw that the number of federal filings increased by about 30% between 2015 when it was passed and 2017. And trade secret filings have remained at about that level, so about increased by about 1/3 during that time. In terms of the uniformity goal, not so much. Really what we're seeing is that those federal courts are still relying on state law principles. So you're still seeing Ohio apply trade secret principles as Ohio has, and California applying trade secret principles as nobody else does, and all of that sort of thing. So uniformity has not really been achieved. There has been some increase with regard to protection for global economic goals. There was more success with this goal. Several district courts have held that the statute has extraterritorial effect. And these holdings are based on 18 U.S.C. 1837, which applies where the offender is a citizen or permanent resident of the U.S. or organized under U.S. law, or there was an act in furtherance of the offense committed in the United States. So a theft of a trade secret here in the U.S. by someone not a resident of the U.S. So success with regard to that goal. Another thing I want to address quickly is what seems to be an increasing debate and analysis of the level of specificity that should be pled in a trade secret case. And this is always, there's always a little bit of a beating of heads when you're working with a client in terms of putting together a complaint where there's a theft of a trade secret, because you're filing these documents, they're going to go into the public record. You don't want to be spilling your guts on your trade secrets because then you've disclosed it, right? But the courts say, well, you've got to give enough information about what your trade secrets are to adequately inform the other side of what they are. So there's this balancing of how much do we have to give, how much can we hold back. And we've seen a couple of recommendations in conferences. There's something called the Sedona Conference, which weighs in on trade secrets issues and is looked to by some courts in analyzing this. And they've identified some principles with regard to trade secret specificity and how that should be pled. First thing they say is the identification of an asserted trade secret during a lawsuit is not a decision on the merits, can't serve as a substitute for discovery. It says that the party asserting misappropriation of a trade secret should identify the alleged trade secret in writing at an early stage of the litigation, not necessarily the complaint, but an early stage. The party claiming the existence of that trade secret should identify the asserted trade secret at a level of particularity that is reasonable under the circumstances, and that a party may amend the identification of an alleged trade secret as the litigation progresses. So there really is this sort of tussle about how much do we put out there initially? Can we file things under seal? But there have been a number of courts that have dismissed trade secret actions where they've said, look, you're just telling me that you have these things, you have these strategies, you have these formulas, you have these processes that are trade secret, but you're not telling me what about them is a trade secret. What is it that makes it so special? Because if I can't, as the court, understand what that is, then the party you're suing can't understand what your claim is. So we're seeing an increasing number of those kinds of cases out there too. So another reason for you to do that due diligence of identifying your trade secrets, understanding your trade secrets, communicating those trade secrets with your employees on how to protect them. And then if it gets to an enforcement action, we'll have to fight about how much you disclose at what point. But lots of developments with regard to trade secrets as well. There is my contact information. I think I actually finished up a few minutes early for lunch. And there's my CLE information as well. I will open it up. Does anybody have any questions? Great. All right. Well, homework for you guys to do, and thanks for your attention. So great to be together in person again.
Yeah, that's so good. Thank you, Debbie. Okay, let me just wrap things up for people who are joining us virtually, because we only had our morning sessions. I didn't think anybody wanted to be on a webinar virtually all day long. So the webinar broadcast will be ending shortly. We will send you the recorded webinar as well as the slides via email within a couple of days for those of you who are online. If you're looking for CLE credit, I will review the CLE codes. You've probably figured out the pattern by now. Debbie's code for the last segment was TH1116D as in dog. If you missed any of the other codes for segment 1, same thing, TH1116A as in apple. Second one, same thing with B as in boy. Third, ending with the C, and then this last segment ending with the D. If you have any questions about that, feel free to reach out to me or my assistant, Laura. If you had any questions that you were unable to get answered today, if you're on the virtual webinar, please email or contact your current Thompson Hine lawyer. If you're not a current Thompson Hine client, feel free to contact any of us who presented today, and we will try to work to address your needs. Again, thank you so much to my presenters from this morning. I think the morning presentation was fantastic. We do have, for those of you who are in Cleveland, we do have lunch available
It's over to my right. So if you go out that door, we are just doing, unfortunately, you know, I usually like to do like a really nice like hot lunch. I feel like a cafeteria lady, but we had to do boxed lunches. There's a variety of salads, sandwiches, but everything is in a single container. So hopefully people are not, you know, serving from the same utensils, et cetera. There are drinks, et cetera. We will be back starting at noon. We have a keynote speaker talking about issues in the hybrid workplace, which I know a lot of people are thinking through and dealing with. So we'll start that at noon. Feel free to take your mask off, eat lunch while she's presenting, go in and out if you need to get something. And then we'll have another presentation immediately after that keynote speaker. So we'll see you back here at noon.